Пані Анно, дуже рада вас бачити.
Доброго ранку навзаєм. Зараз я відкрию, де ви у мене. Да, доброго ранку, Марта. Я включу відео.
Так, ніби все чудово.
Так, все прекрасно, все працює. Я бачу, що мій колега теж онлайн.
Good morning.
Ну, я думаю, що ми почекаємо
We will
учасників, ми ще
wait
не
for the
будемо
participants.
починати.
We'll not start right now. We have 10 minutes to go. You have interpretation button, right?
Переклад, чесно кажучи, я не бачу в
I
принципі.
cannot see interpretation in principle. There is the icon, the globe icon. It's at the bottom in the right corner.
Interpretation. Так, бачу. Да.
I can see it now.
Ну, не те, щоб він мені був потрібний, я просто...
It's not like I need
Мені
one.
головне, я не знаю, а колезі пояснили, моєму колезі?
As my colleague explained, yes, we had a test call with Mr. Bartson, but unfortunately we had no answer from you there, and I cannot see her.
Зараз їй напишу.
I'll write her if she needs any assistance.
Ні, ну ще зарано, може вона приєднається вже трохи пізніше.
До речі, так, у неї презентація на...
Остання, да.
Так, на 10:50, тобто на 9:50 по Страсбургу.
Угу. Я їй написала, я думаю, що все нормально, вона вміє користуватися зумом, так що все буде добре.
Супер. Пані Ганно, а я не знаю, чи ви вчора з нами були. В нас практика була наступна, оскільки багато було учасників, вони пишуть в чаті загальному питання.
Прекрасно, я побачила це. Так, я слідкувала, да. Хочу вам, знаєте, що сказати, я, чесно кажучи, вчора була... трохи, просто на майбутнє, щоб ви знали. Була презентація Летіфа Гусейнова, який спочатку хотів виступати російською мовою, а ви йому сказали ні. Так от, на превеликий жаль, він дуже яскравий саме по собі емоційна людина. Його перекладали, ну, скажімо так, м'яко кажучи, не настільки вдало. Тобто прохання наступного разу. Учасники всі прекрасно розуміють російську. Не позбавляйте їх можливості послухати пряму річ судді без перекладу. Так, зрозуміло, що англомовні учасники, там питань немає, але люди, які можуть спілкуватися російською, будь ласка, для мене це якось дивно. Тобто це було на шкоду учасникам. Це таке рішення.
Пані Ганно, доброго ранку. Доброго
ранку, Наталя. Рада вас бачити.
Я так само. Мені так шкода, бо він же щороку в нас виступав російською мовою наживо. Ну, просто дійсно, і дякую за фідбек щодо перекладачів, ми їх забезпечували, ми це обов'язково врахуємо, але просто так, якби так.
Вони вчора були вже дуже втомлені, я так зрозуміла. Ну, тобто, його промова втратила, мабуть, 50% через рішення заборонити йому розмовляти російською мовою. Ну, таке, просто на майбутнє.
Я думаю, що в нас, в принципі, ми це вітаємо, бо це одна з мов ОБСЄ, тому я думаю, що в наступному році ми це взагалі знімемо питання.
Угу. Добре, ну що, у нас тільки поки що 35, я бачу, до нас приєдналися учасників. Будемо чекати, тому що це якось замало.
Так, доброго ранку.
Доброго ранку. Ви не надсилаєте учасникам якесь там нагадування, що ми скоро починаємо, приєднуйтесь?
Так, ми це робимо через нашу Фейсбук-сторіночку. Вже сьогодні наш комунікатор всім розіслав, то я думаю, що має... Да, зараз, я думаю, приєднається ще.
Ну, добре, давайте ще 5 хвилин, там 6 зачекаємо і будемо починати, добре? Бачу пані Ларису, вітаю вас, дуже рада вас бачити.
Навзаєм, пані Ганно. Це нормально в мене по звуку? Супер,
Так.
дякую.
Доброго ранку всім.
Доброго ранку, Назаре, рада бачити.
Навзаєм. Незвичний формат, але
Так,
краще так, ніж ніяк.
абсолютно згодна. Скільки ми часу даємо додатково? От зараз вже у нас за 2 хвилини буде 9, а скільки ще почекаємо? На ранкову каву скільки даємо часу?
Я пропоную ще як мінімум 10 хвилин дати, щоб більше учасників приєдналося.
Добре.
Лариса, у вас прекрасний учасник нашого форуму.
Привітайся, і щоб ви тебе не чули. Привітайся, он подивися. Це Люцифер, до побачення. Мілкоє зло, іди на диван.
My colleague from Norway joined us. Arnfinn, do you hear us? I've seen you have written in the chat, but I don't see you. Yeah, okay.
Good morning. I can see you and I can hear you.
Excellent. Everything is fine. Everything is working. What is it? Where's it now in Oslo?
It's actually now, it's snowing. So we are getting close to winter conditions, and I understand that this is more or less similar in Ukraine now.
Well, I'm in Strasbourg, so I don't know. I'm missing snow, really.
So hopefully I will be able to go for some skiing this weekend. This is at least my hope. We will see.
Excellent. Colleagues from Lviv, are you having snow? Nazar,
I'm in Kyiv, so we don't have any snow. It's cold, but without snow.
Okay, so we decided to give, 5-7 more minutes for others to join us. It's still early in the morning. People are having their coffee. So, well, I think we start in 5 minutes. For the time being, we are only 57. Actually, we should be much more, if I understand correctly. We have about 300 participants, according to the figures I've seen yesterday. Yes, I see in the chat that there is snow in Lviv. Yeah, so Lviv is closer to Oslo than... Yeah. Марта, то прохання від Назара приєднати його до групи панелістів.
Ігор, якщо ви нас чуєте, можете, будь ласка, його приєднати?
Так, звичайно, хвилинку.
Дякую.
Доброго всім ранку, радий всіх бачити. Дякую, мене вже приєднали.
Прекрасно, рада бачити, Назаре.
Приємно.
Так, ну у нас потрохи стає більше, але так повільно.
Доброго всім ранку, радий всіх бачити. Дякую, мене вже приєднали.
Прекрасно, рада бачити, Назаре.
Приємно. Запитували про перший сніг у Львові. Так от це, власне, вид з мого вікна. Вже бачите, засніжено, вже так Львів входить в такий новорічний настрій різдвяний. Вперед.
Це парк, я не бачу.
Ну, це такий дендрарій лісотеху.
Супер. Ну що, дорогі колеги, я пропоную починати, може, да, решта підтягнуться.
So, dear colleagues, I suggest to start and the rest will follow. So, good morning, everyone.
Good morning, dear colleagues, dear friends. I will speak both languages this morning because I have my double role as a moderator and also speaker. I'm very happy that our traditional event, Lviv Annual Forum, continues even during the pandemic. Although it's a great pity we cannot enjoy Lviv and its very unique atmosphere this year. So I already promised my colleagues who kindly agreed to participate this year online that next year they will be invited to come also physically, and they will have a chance to be in this fantastic city and to experience it. But the advantage of online meeting is, of course, that much more people are capable to join us, and even more will watch the event in YouTube. I followed yesterday, also partially the first day, very interesting discussions. I've seen the interest. I hope this day will be fascinating as well. And we start our first session, in which we have 3 presentations by the court judges. My dear colleagues, Judge Arfin Bartson and Judge Yulia Motok. Arfin is with us now. Yulia will join later. I will introduce them, of course, when they will make their respective presentations. And I thank them now wholeheartedly for their agreement to come, this time virtually again, to Ukraine to meet with you. And now I have to put on my second cap as a speaker, and I will switch to Ukrainian. Моя тема сьогодні
My today's topic is
ненависті.
the hate speech.
Звичайно, це
Of course,
дуже цікава
this is very
і
interesting
багатоохоплююча тема,
and
і
comprehensive
вкласти
topic,
навіть поверхово всі
and
аспекти
even
коротеньку
superficial
презентацію
review of all
неможливо.
aspects is impossible in a quick presentation. About 5 years ago at this very forum, we have started to discuss the hate speech, how the court evaluates the complaints on the violation of freedom of speech when it applies Article 17.
А коли він робить балансувальний тест на підставі
Provision
принципів,
or when it
висловлених
makes
за
balancing
статтею
tests
10.
based on
Але
principles of
сьогодні я
Article 10.
хотіла поговорити не про 10
Today,
статтю,
I would
а
like
про
to discuss
дещо
not Article
інше,
10, but
а
something
саме
else.
про
That
позитивні
is the
зобов'язання
positive
держави в
commitments of the
контексті
country
мови
in the context
ненависті
of
і
hate speech
злочинів
and
на
the
ґрунті
crimes on the
ненависті,
basis
які, як
of
ви розумієте, дуже
hate,
пов'язані.
which are
Ну,
very related, as you
зокрема,
understand,
що
in
стосується
particular as
прославляння
regards
насильства
the
та
glorifying of
тероризму.
violence and
В
terrorism.
контексті статті
In the context
10
of
ми з
Article
вами це
10,
обговорювали,
we have
суд
discussed
мав
this. The
можливість
court had the
розробити
opportunity to
відповідні
develop the
принципи
appropriate
в ряді
principles
справ
in the
стосовно
number of
подій
cases
в
regarding the
Південно-Східній
events in
Туреччині, де
southeastern
були
Turkey,
серйозні
where there were
зіткнення
serious
між
clashes
силами
between
безпеки
the
і
security forces and the
членами
members
РПК, або в
of
таких справах, наприклад,
RPK,
як Лерой проти Франції,
or
де
in cases
заявник
like Leroy
намалював
versus France,
карикатуру
when
з
the
палаючими башнями з
applicants
вісниками в
wrote
Нью-Йорку
in
і
caricature
надписом
with flaming
«Ми всі мріяли про
twin
це,
towers in New
Хамас
York
це
and
зробив».
with inscription we
А
all
у
dreamt
справі
about this and
цього
Hamas did
року
this.
Макучан і
And in the case this
Мінасян
year,
проти
Makochan and Minasan
Азербайджану
versus
і
Azerbaijan
Угорщини
and
щодо
Hungary
досить відомої
on
події
quite
варварського
well-known events of
вбивства
barbarian
азербайджанським
murder
солдатом
by Azerbaijan
вірменського
soldier
солдата
of
та
the
замаху
Armenian
на життя
soldier
іншого
and attempt
вірменського
at
солдата
another
під час
Armenian
спільного навчання в
soldier
Угорщині.
during the joint training in
Там
Hungary.
молодого чоловіка було
The
засуджено
young
в
man
Угорщині
was
до
convicted in
довічного
Hungary
позбавлення волі.
to
Через 8
life
років його
imprisonment,
було
and after 8
передано
years he was
для
transferred
подальшого
to
відбування
Azerbaijan for
покарання, проте на
further
батьківщині його
punishment, but in
зустріли як
his homeland he
героя,
was met as hero,
помилували, надали
he was
житло,
acquitted,
урочисто
he
підвищили
received housing,
військовому рангу,
he was
сплатили
promoted
заробітну
in
плату
rank,
за
he
роки
was paid
в'язниці,
out the
і
salary
високі
for the time in
посадові
prison,
особи
and the high
прославляли його
officials
як
glorified him
патріота,
as the
як символ
patriot, as the
нації.
symbol of the
Сайт
nation.
президента
The
держави
website of the president
присвятив
of the
йому
state dedicated
сторінку,
to the webpage to him. Anyone could leave
І
greetings
оця
to him at this
героїзація
page.
злочину
This
вищими
glorifying of
посадовими
crime by
особами
high
на тлі
officials
тривалого
against the backdrop of long-term
вірмено-азербайджанського
Armenian-Azerbaijan conflict
не тільки фактично
not
надали
only actually
засудженому
provided
безкарність за
to the
злочини,
convicts impunity
вчинені
for the
проти
crimes
вірменських
committed
жертв,
against
але
the
суд
Armenian
визнав
victims,
саме
but the
цю
court recognized that this
злочину
glorifying
проти
is
вірменських
the crime
солдатів
against
і схвалення
Armenian
цих дій
soldiers, its approval of
високопосадовцями
these
та, на
actions
жаль,
by senior officials and Azerbaijan society at large is violation of Article 14 in combination with positive commitments according to Article 2 of the Convention.
В справі Ідентова та інші проти
In the case in Toba
мова
and
йшла
Habas versus Georgia,
напад на
was
гей-парад
about attack at
званими
gay pride by so-called
православними
Orthodox
групами, де
groups,
саме
in in which the word violence reached the threshold of Article 3 of the Convention. During the clashes between participants of the march and representatives of two religious groups, the court mentioned that the latest were especially influenced in the language they used. They angrily called the participants of the march terrorists and so on. They used the terms like destroyed, burned alive. In these serious circumstances, the court rules that the court believes if there were physical damage caused to the participants is not so important. The word and sporadic physical attack had the objective of frightening the participants, and the violence, which consisted of hate speech and serious threats mostly, also some sporadic physical violence, and as illustration of reality of threats, caused the fear and concern, which were quite serious, to reach the threshold of Article 3 in combination with Article 14 of the Convention. Besides, the state authorities did not fulfill their procedural commitment, although there were multiple complaints filed by the applicants on harsh treatment and inaction of the police. The state agencies did not do serious and deep investigation of the circumstances of the events regarding all the applicants. Instead, for unclear reasons, they limited the scope of investigation. They opened only 2 proceedings on the physical harm, which led only to one result: application of administrative punishment to 2 counts for protesters. But due to intensiveness of violence targeted against the applicants, this is not sufficient. It's not enough to punish only for specific physical harm in this situation. It was not enough, because the government had to apply all the reasonable actions to establish possible homophobic background of these events. And the absence of serious investigation from the law enforcement agencies led to the situation that the offense that was motivated by hate and bias was treated as regular offense, which is deprived of this subtext. So this was identical in the view of the court to silent or even official approval of the crime motivated by hate. The court have analyzed that in the Criminal Code of Georgia there are sufficient provisions that could have become more suitable grounds for initiating criminal investigation against violence. And what is more important, the national criminal legislation directly envisaged that discrimination based on sexual orientation and gender identity should be reviewed as the motive of bias and is the aggravating circumstance. And the lack of proper investigation, non-applying these provisions of the law, became the violation of Article 3 together with Article 14. It's not enough just to investigate and to punish the fact of violence as such. We have to be able to review this background of hate which caused the violence. But in this context, what is important is not only that Article 3 requires criminal response to the hate crimes and hate speech. When we talk about Article 8, for example, when there are hidden calls for attacks on physical and mental integrity, this also requires the protection of criminal law. Recent case, Beizaras versus Lithuania. 2 young men placed the photograph of their kiss on Facebook. The photograph received hundreds of serious homophobic comments, the calls to castration, to send it to gas chambers, murders. The prosecutor's office and courts refused to bring them to criminal liability, establishing that the behavior of the applicants in this situation was eccentric and not in line with traditional family values of Lithuania. And the comments did not reach appropriate thresholds of being able to be punished. The European Court refused the comments that comments in Facebook are less dangerous than the comments on news portals and the internet, the Delphi case, and the number of negative comments did not exceed the number of comments from followers of the applicants, and it established that they suffered discrimination. But the court recognized that the way criminal sanctions, in particular against the persons responsible for the most serious signs of hate and stirring up to violence, should be applied as the measure but it has equal concern for the hate speech against sexual orientation and sexual life of other individuals. This case was about unhidden calls for attacking the physical and mental integrity. As the consequence, what was required was the protection by the criminal law. Although Lithuanian criminal codes, in theory, envisaged this protection, but in practice, the applicants were refused as a consequence of discriminatory attitudes of the government, which did not fulfill its positive duty to efficiently investigate. If these comments constitute the stirring of violence and hate, there are cases on positive duties on Article 8, which established the needs of criminal prosecution for the hate speech were about rallies against Romas in Hungary. I'd like to discuss the first one, RB versus Hungary, on demonstration of right-wing political party organized in micro-neighborhood of Romas. During these rallies, they had anxious whips and they had word offensive against Roma representative, a female who observes this rally from her garden. So they go inside the dirty, hated gypsies. They declared they would build the house on their blood, but the criminal offense and the incident did not establish any persecution or violent actions against a member of the ethnic groups. The European Court ruled that the positive commitment can appear when the behavior is motivated by the bias and it constitutes the intrusion into implementation by the applicant of the right to respect his private life envisaged in Article 8, when the individual has justification to prove that they were affected by racially motivated persecution with physical and words offenses. This is the situation of our applicant. When the evidence shows the existence of trends to violence and intolerance to ethnic minority, then the state has positive commitments which envisage higher level of requirements to respond to these incidents. In this case, it's obvious the applicant suffers the threats from the right-wing member because of her Roma background, and the need to investigate the discriminatory motives was even more acute because it was not a separate case but the part of general hostility to the Roma community. In Hungary's system of law, there are articles of criminal codes on violence against the members of the group and stirring to violence against the group. They could have been the proper grounds for opening the criminal investigation on the applications on the racist motives, but in this case, the law enforcement agencies made the conclusion that the objective side of the crime, of the violence against the members of some group, could not be established, and there were no grounds to continue the investigation, although they had the evidence that the word violence targeted against the applicant was grounded on the racist motives. Thus, the applicant could not use the proper protection from the offense on her integrity, and the application of existing criminal mechanisms was imperfect, which caused the violation of positive commitments of the state according to the Article 8. The same positive commitments appear on Article 9 of the Convention, and 2 weeks ago the court published the group of cases, several cases versus Ukraine, which concern different attacks on religious community of Jehovah's Witnesses. I'd like to draw your attention that these cases were accepted, these judgments were adopted by the committee. And some settings in few docs may not allow you to see them, but you know that the great majority of the decisions are adopted by the committee of 3 judges if they are about more or less sustainable provisions of the Convention. And so this cases, some of them were in Article 3, but the case I'd like to discuss today, Migurano and religious community of the Jehovah's Witnesses of the city of Ismail versus Ukraine. It was about the incidents in the course of which the group of Orthodox Christian believers disrupted the ceremony carried out by the community of Jehovah's Witnesses. During this incident, the first applicant was hit in his breast, but the complaint on Article 3 was deemed unacceptable because it was not so serious to reach the threshold of Article 3. As regards the Article 9, it violated when they started the case on administrative offense because there was limited seriousness of the offense suffered by the applicant community. The answer was based on administrative proceeding. It could have been feasible, but the government had to properly explain the reasons of any decisions it made. The attacker was fined for administrative offense for petty crime, but as a result, the criminal proceeding was initiated with arrest for 5 months. It was also related to the crime, the criminal offense. So the behavior of government agencies follows the pattern, and so the courts referred to the conclusions of the Committee on Human Rights, and this pattern was declared problematic.
The court actually already criticized Ukrainian authorities due to inter-ethnic tensions. You know that case, it was about Roma camps, and such reflections were also used here. The European Court, which normally does not interfere in the interpretation of the new national law, here makes some interesting analysis and says the classification of hooliganism as a rule hides a key aspect of interconfessional hostility, which was in the basis of the institute. And this is associated with the fact that in Ukrainian legislation, one of the key characteristics of this crime, hooliganism, those who are guilty need to have a motive for this. So these actions are motivated by simple neglect towards social norms and the wish to demonstrate his or her advantage. The actions of those people who actually disrupted the gathering of Jehovah's Witnesses wanted to counter their activities. And it's hard to imagine how they could be classified as those which are spurred just by neglect to social rules. And even though the national authorities, first of all, need to interpret and apply internal legislation first of all, and the classification of hooliganism as such could not be problematic if it allowed to react to the incidents in due way, as associated way. So in this case, the classification of hooliganism caused the suspension because the actions were lacking the motivation of hooliganism. The question which was legally stemming from this conclusion, but due to ununderstandable questions was never reviewed. It was like, what was the motivation which was behind these actions? And actually, in spite of the contrary proof, it was interpreted as something where an unknown person actually identified it. And in the context of classic criminal proceedings, the authorities delayed it using legal classification, which actually prevented to take into account the context of interreligious tensions and hostility, even though the authorities, the Ukrainian authorities did not comply with their positive obligation to ensure this mutual tolerance between the religious groups which oppose each other, and therefore there was a violation of Article 9. I mean, the only issue which the court reviewed in those cases is whether the criminal law had to ensure respect to the rights of applicants according to Articles 8, 9, and 14. And from here, we can draw a conclusion that in the circumstances of each cases, the authorities had obligations based on the Convention to react to hostile language, to hate speech, based on on the existing
Зокрема, вони
provisions of
мали
criminal legislation. In
використати як
particular, they
основу
had
для
to use
розслідування
as the
положення
basis for
кримінального
their
права, які дозволяють дізнатися про мотиви
investigation those
ненависті.
provisions of
Зокрема, в
criminal
українських
law which
справах мова
allow
йшла
to find out the
зрозуміло про
motives of
статтю
hate.
161
It was
кримінального
Article
кодексу.
161, the criminal case,
Ви
the
прекрасно
criminal code
знайомі
in
з
Ukrainian's
судовою
case.
практикою
Well,
щодо
you know
позитивних
very well
зобов'язань,
the
що
case
кримінальне
law and
право
positive
має
obligations that the
використовуватися
criminal
для
law
того,
has
щоб
to be used
переконатись, що
to
приватні
be
особи
convinced that private
дотримуються
persons
певних прав
actually
конвенції,
comply
зокрема за
with some
статтями 2
convention
і
rights,
3.
in particular Articles 2
Це,
and 3.
звичайно, вимагається, коли мова йде про
And of
насильство.
course, this is
Але
about
ці справи
violence,
демонструють,
but
що
these
мова
cases
ненависті
also
настільки
demonstrate
потенційно
that
небезпечна,
hate speech is
що
so
кожного
potentially
разу, коли є
dangerous that
підозра
every time
на
when
расистський
there is
або
suspicion
гомофобний мотив
about racist or
виступу
homophobic
злочину,
motives,
фізичних погроз,
like
конвенція
crimes
вимагає,
or
щоб це було
physical
належним
threats,
чином
the convention
враховане
requires
під
that
час
this is duly
розслідування,
taken into
і
account
це
during the
випливає із
investigation, and
позитивних
this stems
зобов'язань
from
за
positive
статтями
obligations
8
according to
і
Article
9
8
разом
and
із
9,
статтею 14.
along with
Я
Article
думаю, що
14.
я
I
вичерпала свій
think that
час.
I
Як
have already
модератор я
exhausted
буду
my
до
time. As a
себе
moderator, I'm
в
going
цьому
to
плані
be
критично, тому
critical towards
я поки
myself.
не
So
бачу питань
for
в
now, I
чаті,
don't
я
see any
вибачаюсь, вони
questions in
є.
the chat. Are there any?
Я втратила зв'язок.
I have lost connection. It seems to me. I have just lost touch.
Да, дорогі колеги, я дуже прошу вас ставити питання.
I really ask you to...
Це є, да, я отримала відповідь, що все добре.
I got an answer that everything was fine.
Є питання?
Are there any questions?
Ну, прекрасно, питань немає. Я думаю, що це така тема, яка, в принципі, досить добре знайома. Я просто хотіла наголосити на останніх важливих розвитку судової практики.
And the development of case law.
Я повертаюся до своєї ролі як модератора. And now I come to my dear colleague, Judge Arnfinn Bartsen, judge elected in respect of Norway, who recently moved to Section 5. And now we work together, and Ukrainian cases benefit from his extensive judicial experience. Judge Bartsen received his doctorate degree from the University of Bergen. He was president of the Gulatin Court of Appeal during 5 years, and then justice at the Norwegian Supreme Court during 10 years before he joined the European Court of Human Rights. Today, he will speak about the duty to investigate cases of trafficking. That's a very pertinent topic for a country like our one. Unfortunately, Ukraine is one of the main countries of origin of victims of trafficking in Europe, as you might know. Arnfinn, you have a floor.
Thank you so much, and good morning to everyone. And let me start by thanking the organizers for inviting me to this year's event, and I address you from my home in Oslo in Norway. And like so many others, I am teleworking these days. I hope you are all safe and sound, and I encourage you to keep up the spirit. I will deal with human trafficking as seen from the point of view of the European Convention on Human Rights. And although trafficking regularly will trigger questions under a number of provisions in the Convention, such as, among others, Article 3 and 8, I will this morning focus only on Article 4. And this provision prohibits slavery, servitude, forced and compulsory labor. As announced by the title of my intervention, I will in this regard, moreover, concentrate on, in particular, two legal clarifications that came about with the court's Grand Chamber judgment, June 2020, in the case of SM versus Croatia. The first clarification concerns the relationship between international law on human trafficking and the convention as to the scope of protection. And the second consolidates the convention law as to the member states' positive procedural obligation to carry out an effective investigation of potential cases on human trafficking. As you know, there are several international legal instruments that define human trafficking and prescribe measures that must be taken by the participating states in order to fight this evil. And the Grand Chamber judgment in SM versus Croatia contains ample references to this material. For our purposes, I mention in particular the UN Convention Against Transnational Organized Crime, adopted in 2000 in force from 2003, with 190 parties. One of 3 protocols to this convention is the so-called Palermo Protocol from 2003, and the protocol to prevent, suppress, and punish trafficking in persons, especially women and children. This is the first global legally binding instrument with an agreed definition on trafficking in persons. And the intention is to facilitate convergence in national approaches that would support efficient international cooperation in investigating and prosecuting trafficking in persons cases. An additional objective of the protocol is to protect and assist the victims of trafficking. The definition of trafficking in persons is, according to Article 3A of the Palermo Protocol, threefolded, comprising of, first, a list of actions, second, a set of means, and third, the prerequisite of exploitative purpose. Accordingly, the Palermo Protocol defines trafficking in persons as follows: the recruitment, transportation, transfer, harboring, or receipt of persons. This is the action, the first element. And then, by means of the threat of use of force or other forms of coercion, of abduction or fraud, of deception, of the abuse of power or of a position of vulnerability, or of the giving or receiving of payments or benefits to achieve the consent of a person having control over another person. And this is the list of the means. And then the third element, for the purpose of exploitation. And exploitation shall include, at a minimum, the exploitation of the prostitution of others or other forms of sexual exploitation, forced labor or services, slavery or practices similar to slavery, servitude, or the removal of organs. And I also mentioned that if the victim is a minor, that is under the age of 18, then there will be trafficking even in the absence of the specific means set forth in the definition. Well, the definition of trafficking in the Palermo Protocol has been taken on board in the Council of Europe's Convention on Action Against Trafficking in Human Beings. This is the so-called Anti-Trafficking Convention in force from 2008. The aim also of this instrument is to establish a comprehensive framework for the protection and assistance of victims, as well as to ensure effective investigation and prosecution, and to promote international cooperation on action against trafficking in human beings. And in addition to applying and clarifying further the definition of trafficking in human beings in the aforementioned Palermo Protocol, the Anti-Trafficking Convention has a more far-reaching scope. It is made clear that it covers all forms of trafficking in human beings, whether national or transnational, and also irrespective of whether it is part of organized crime or not. So, a search for the words human trafficking, trafficking in human beings, or trafficking in the European Convention on Human Rights will be in vain. This legal concept was not in use in 1950 when the convention entered into force. And there is no additional protocol on this issue either. And here we can compare with the European Union's Charter of Fundamental Rights, Article 5, that has actually an explicit prohibition on trafficking in human beings. The European Convention on Human Rights is yet indeed highly relevant also when it comes to human trafficking. The court's ruling in SM versus Croatia being an important reason for that. So let's turn to that case. The applicant, SM, was a Croatian national who was born in 1990. She lodged a criminal complaint in September 2012, alleging that a man, TM, had forced her into prostitution over several months in mid-2011. According to her, TM had contacted her via Facebook as a friend of her parents, promising to help her find a job. However, at the first meeting, he had driven her to a man's house to provide sexual services, assuring her that this was only until she found a job. And that situation had then led to her having regular clients, either in the flat he had arranged for them to live in, or by driving her to meet them. So she alleged that she had been under TM's control, that he had made her give him half of what she had earned from providing sexual services, and that he had threatened her and punished her. She had eventually telephoned a friend whose boyfriend had helped her to escape, and then stayed with her friend and friend's mother for the next 6 months. When TM started contacting her again via Facebook with threats, she decided to turn to the police. And so the police carried out a preliminary investigation and established that TM had a previous conviction for procuring prostitution, using force, and for rape. They searched TM's premises and his car and found condoms, 2 automatic rifles, a hand grenade, and a number of mobile phones. At the end of 2012, TM was indicted, and the applicant was officially given the status of victim of human trafficking. TM was then brought to trial in 2013. However, he was acquitted for forcing the applicant into prostitution. The domestic courts found the applicant's testimony incoherent and unreliable, in particular because it contradicted in places the evidence provided by the friend who had helped her to escape. The courts therefore concluded that the prosecution had failed to provide sufficient evidence for the conviction and that the applicant had given sexual services voluntarily. An appeal to the state attorney's office was dismissed in January 2014, and the constitutional complaint by the applicant was declared inadmissible in June of the same year. So the applicant lodged her application with the European Court of Human Rights, relying on Article 4 of the European Convention. Before the Grand Chamber, it was an important question of interpretation whether human trafficking is only covered by Article 4 of the Convention to the extent that it can also be considered as being slavery, servitude, or forced or compulsory labor, or whether Article 4 can be read to the effect that human trafficking as such is encompassed by that provision as a separate category on a standalone basis. The court had already taken the latter position in some earlier cases decided by a composition of 7 judges in chamber, notably in Rantsev versus Cyprus and Russia in 2010, followed by other judgments. In Rantsev, the court said, "There can be no doubt that trafficking threatens the human dignity and fundamental freedoms of its victims and cannot be considered compatible with a democratic society and the values expounded in the Convention. In view of its obligation to interpret the Convention in light of present-day conditions, the court considers it unnecessary to identify whether the treatment about which the applicant complains constitutes slavery, servitude, or forced or compulsory labor. Instead, the court concludes that trafficking itself, within the meaning of Article 3 of the Palermo Protocol and Article 4 of the Anti-Trafficking Convention, falls within the scope of Article 4 of the Convention. And in SM versus Croatia, the Grand Chamber was now, for the first time, invited to confirm or to reject this interpretation of Article 4. And in short, the Grand Chamber embraced the approach in Rantsev, and it highlighted also the following, and I cite, The court further notes that in its subsequent cases, while regularly referring to Rantsev, it sought, that is the court, to provide an explanation on how the phenomenon of human trafficking falls within the scope of Article 4 of the Convention. Thus, for instance, in J and others versus Austria, the court explained that the identified elements of trafficking, the treatment of human beings as commodities, close surveillance, the circumscription of movement, the use of violence and threats, poor living and working conditions, and little or no payment, cut across the three categories set out in Article 4. Similarly, in Chaudhary and others, the court stressed that exploitation through work is one of the forms of exploitation covered by the definition of human trafficking, and this highlights the intrinsic relationship between forced and compulsory labor and human trafficking. And then the Grand Chamber confirmed that the interpretation that trafficking as defined in the Palermo Protocol was then covered also by Article 4 of the Convention. And as I mentioned initially, there is a difference between the Palermo Protocol and the Anti-Trafficking Convention as regard the scope of their application, the latter being applicable to all forms of trafficking in human beings, whether national or transnational, and whether or not connected with organized crime. And in the Grand Chamber case in SM versus Croatia, the Grand Chamber also confirmed that the interpretation of Article 4 will include the definition in the Anti-Trafficking Convention. So the court summed up in SM versus Croatia as to the scope of Article 4. It says, thus, the court finds that from the perspective of Article 4 of the Convention, the concept of human trafficking covers trafficking in human beings, whether national or transnational, whether or not connected with organized crime, insofar as the constituent elements of the international definition of trafficking in human beings under the Anti-Trafficking Convention and the Palermo Protocol are present. This was the first element that was now clarified by the Grand Chamber in this case. And then the nature and scope of the positive obligations concerning human trafficking and forced prostitution under Article 4, they had already been comprehensively set out also in the previous Rantsev case, Rantsev versus Cyprus and Russia. And the court did that under three headings. First, the duty to put in place a legislative and administrative framework to prohibit and punish trafficking. Second, the duty in certain circumstances to take operational measures to protect victims or potential victims of trafficking. And three, a procedural obligation to investigate situations of potential trafficking. In general, the first two aspects of the positive obligation can be denoted as substantive, whereas the third aspect designates the state's positive procedural obligation, a procedural obligation to investigate situations of potential trafficking. And this positive procedural obligation, the duty to investigate, connects to the court's case law on a similar duty related to potential violations of, in particular, Article 2 and 3 of the Convention. Article 2 being the protection of the right of life, and Article 3, the prohibition of torture and so forth. And traditionally, ever since Ciliardine versus France, the court has said that the principle of procedural obligation under Article 2 and Article 3 of the Convention also informs the content of the procedural obligation under Article 4. So here the court connected those articles in the Convention also when it came to the content of the duty to carry out an investigation. And in the case SM versus Croatia, the Grand Chamber case from this year, the Grand Chamber confirmed this approach and said that it saw no grounds for revisiting that well-established approach. Moreover, as the court also had stressed in the French case, Siliadin, possible defects in the relevant proceedings and the decision-making process had to amount to a significant flaw in order to raise an issue under Article 4. In other words, the court, the Strasbourg court, is not concerned with allegations of errors or isolated omissions, but only with significant shortcomings, namely those that are capable of undermining the investigation's capability of establishing the circumstances of the case or the person responsible. In this respect, the court made some important clarifications in SM versus Croatia, which can be summarized in the following 3 points. Firstly, the authorities must act of their own motion once the matter has come to their attention. In particular, they cannot leave it to the initiative of the victim to take responsibility for the conduct of any investigatory procedures. Secondly, the procedural obligation is a requirement of means and not of results. There is no absolute right to obtain the prosecution or conviction of any particular person where there were no culpable failure in seeking to hold perpetrators of criminal offenses accountable. Thus, the fact that an investigation ends without concrete or with only limited results is not indicative of any failings as such. And moreover, thirdly, the procedural obligation must not be interpreted in such a way as to impose an impossible or disproportionate burden on the authorities. Nevertheless, the authorities must take whatever reasonable steps they can to collect evidence and elucidate the circumstances of the case. And in particular, the investigation's conclusions must be based on thorough, objective, and impartial analysis of all relevant elements. Failing to follow an obvious line of inquiry undermines to a decisive extent the investigation's ability to establish the circumstances. So, turning then to as the final element of my intervention to the court's concrete assessment, the court noted that TM had allegedly first contacted the applicant via Facebook, as I mentioned, which is one of the recognized means used by traffickers to recruit their victims. That was also true of the alleged promise of employment, accompanied by the applicant's belief that she had no reason for concern. Furthermore, the applicant's allegation that TM had arranged accommodation so that she could provide sexual services suggested the element of harboring as one of the constituent actions of trafficking. And moreover, the applicant's personal situation undoubtedly suggested that she had belonged to a vulnerable group, while TM and his position and background meant that he had been capable of assuming a dominant position over her and abusing her vulnerability. So in sum, and this is a key element, the applicant had made an arguable claim before domestic authorities that there had been prima facie evidence that she had been the victim of treatment contrary to Article 4. So the court therefore found that the procedural obligation to investigate under Article 4 had been triggered in the applicant's case. And then the court concluded also that there was a lack of following some obvious lines of inquiry. I will mention them very briefly. There had not been any effort to inquire into the applicant's and TM's Facebook exchanges. The police had not obtained evidence from the applicant's parents, in particular her mother, who had apparently previously had contact and difficulties with TM. They had not attempted to identify or question the owner of the flat or the neighbors where the applicant and TM had lived. And they had not interviewed the mother or the boyfriend of the friend she had telephoned for help. So instead of following these lines of inquiry, the prosecuting authorities had relied heavily on the applicant's statement and had, in essence, created a situation in the subsequent court proceedings where her allegations simply had to be pitted against the denial of TM without much further evidence being presented. At this point, the court referred to the fact that international bodies had stressed that one of the requirements of effective investigation and prosecuting of human trafficking offenses was to avoid over-reliance on the victim's testimony alone by clarifying and supporting it with other evidence. So the court concluded that the shortcomings in the conduct of the case by the prosecuting authorities had in sum fundamentally undermined the domestic authorities, including the relevant courts' ability to determine the true nature of the applicant's and TM's relationship, and therefore also whether the applicant had been exploited by him, as she alleged. And accordingly, there had, in the applicant's case, been a violation of Article 4 of the Convention. I'm just about to end my intervention, and I will do so by emphasizing very briefly 3 general outtakes from the judgment beyond the context of Article 4, going rather to the court's role and operation in general. And firstly, the Grand Chamber judgment in SM versus Croatia demonstrates the Grand Chamber's general role in clarifying the law under the Convention with a normative impact for all 37 member states and to the benefit of 830 million people. Secondly, the judgment is the clear example on the court securing that the Convention remains a living instrument that is interpreted in light of the present-day conditions in a manner that makes the Convention rights and freedoms effective not only in theory but also in practice. And thirdly, we can clearly see that the court, in interpreting the Convention in an evaluative manner, is indeed informed by current developments in international law, in this case, in particular, the Palermo Protocol and the Anti-Trafficking Convention. This leads me to the end of my intervention, and I thank you so much for your attention.
Thank you very, very much, Arvin. I just want to let you know that there is certain delay in questioning because I only now received some question to me. I now invite our participants to write as soon as possible questions to Judge Barnson. If not now, maybe at the end he will reply. For the time being, I have one question to you, which came from Judge Bushchenko. He is judge of the Criminal Chamber of the Supreme Court of Ukraine. And unfortunately, he apologized. He sent his question and he was called for deliberations, but he will listen to your answer in YouTube because everything is recorded and will be presented. So his question relates more to domestic violence issue rather than trafficking. And the question is the following. Dear Judge Barnson, our legislation implemented some approaches of the Istanbul Convention in criminal proceedings, among others, prohibition to drop the prosecution when victim withdraws her or his complaint, if the case is connected with domestic violence. In some cases, however, national authorities construe this provision in some broad manner that, in my opinion, is wrongly equating domestic violence to violence happened between family members. What is your opinion as to the features that might help to distinguish domestic violence from other forms of violence between relatives or family members? Thank you very much.
Thank you so much. I think I need to be very careful when I enter this discussion because it appears to me that this is first and foremost a question of domestic law. And I am not at all inclined to draw up any finer borders within the limits of domestic Ukrainian law. I think, but in general, I can see the problem that is addressed here. But in general, I would say that it would be sad if the general effort to fight also domestic violence should end up in a very fine distinction as to what is domestic violence and what is not. we have also to take into account when it comes to the interpretation of the convention, that this distinction is not necessarily decisive as to whether there is an obligation to investigate. Because in the event of there being some kind of violent affair, that will in general trigger the duty to investigate now under the convention, whether this is perceived as being domestic violence or some other kind of violence. So I think as a matter of convention law, I'm not sure whether this distinction would be really decisive. And I will of Ukrainian domestic law to those that are in a far better position than me to answer that question.
Thank you very, very much. I have two more questions to you. One came from Mr. Vitaly Klitschko. I'm terribly sorry for the sound. Is contested prostitution, sexual exploitation covered by Article 4? Consented prostitution, sorry.
Well, this is in the chamber judgment. If one reads the chamber judgment in SM versus Croatia, I think it is open to discussion whether actually that could be read to that effect. And of course, that would trigger a huge debate in the European context, because we don't have in all member states of Europe any prohibition of what we now within the frame of this question perceive as consented prostitution. That would be prostitution with the lack of the elements of force or the other means that are actually mentioned in the definition of human trafficking in the Palermo Protocol. That must be the framing of the question. So if prostitution really is voluntarily, then the answer would be that no, Article 4 will not be prohibited under Article 4. And this is, I think, made very clear in the Grand Chamber judgment, that this is not a judgment that will prohibit prostitution as such, because that would probably have triggered some heavy debate among the member states, because in some member states this is completely legal as such, if the elements of trafficking is not there. So my answer to this would be no. The Grand Chamber judgment it will not say that Article 4 also then encompass what we have labeled as consented prostitution.
Thank you very much. And the last question so far from Mrs. Anna Politova. Is the aim of exploitation is always necessary for trafficking of human beings?
In short, yes, under the definition of Palermo Protocol, this is one of the three necessary elements in order to label this as trafficking. But indeed, and I have to highlight this, even if one conclude that this is not trafficking under the Palermo Protocol, there might be situations where the situation even is covered by Article 4 or other articles in the convention. It might be Article 3, it might be Article 8. So, I mean, the main point take out from SM versus Croatia is that the definition in Palermo Protocol and the anti-trafficking protocol, that is at least what is covered by Article 4. But there might be cases, and I believe the Grand Chamber also states this very clearly in the judgment, there might be situations where Article 4, Article 3, Article 8 also will encompass something that is not defined as trafficking under the Palermo Protocol. But as for the label trafficking, yes, there is a need to have this element of exploitation. If not, this is not trafficking according to the Palermo Protocol definition. Thank you.
Thank you very, very much for your excellent presentation of course, and for this brilliant reply. So dear colleagues, Judge Barton kindly stays with us. If you have more questions, you still can write. And I see that Judge Motok joined us. Yulia, good morning. We come now to our third presentation. It's my pleasure to introduce Judge Yulia Motok, who already attended this forum in Lviv 4 years ago. We stayed in the same section for 2 years. And of course, Judge Motok is well aware of Ukrainian case law and our particular issues. She had chosen today a topic of the Convention and the EU Charter for Fundamental Rights, and she is the best place to address it, as apart from being a judge of the European Court of Human Rights and previously a Constitutional Court judge, and apart from being a member of UN Human Rights Committee and UN Special Rapporteur, she was also a member of the Fundamental Rights Agency of the European Union. So she is the one who is the best place to say about these two important legal instruments. Judge Motok, you have a floor.
Thank you very much, Gana, for inviting me. I am very happy to be among the participants in the forum of Lviv. Even if we are now at distance, we cannot see the beautiful city of Lviv, but I have very good souvenirs for this city and for the participant as well to this forum. So my topic today is the relationship between the Convention and the EU Charter of Fundamental Rights. And it is a very interesting topic. I don't know how much our audience is familiarized with the Charter of Fundamental Rights, but when you start to talk about the relationship between the two convention, is not that you are going to start to talk about two treaties in general, but you have to talk about two systems of law. And the systems of law are very, very different between, because as you know, the conventions apply to all member states and in all respects, all the areas. But the charter applies only to the areas that are covered by the EU legislation. So this is fundamental to know, that we can, if we belong to a state that is a member of the European Union, we can invoke the convention for any topic, but we cannot invoke the charter for any topic if this topic is not covered by the charter. This is a very important element, and we have to know which is the field of application of the EU law. Regarding the history of the relationship between the Charter and the EU law, we have to take into account that if the Convention is now at its 70th anniversary, the Charter is a newer instrument, but so it was adopted in 2000 at the conference in Nice. It became compulsory only in 2009, but by the Treaty of Lisbon. But it doesn't mean that before the adoption of the Charter, the European Union didn't have applications of the human rights or ignore the human rights. I think it was the opposite, and so the history of the relationship between the two courts starting a long time ago. If we have to look now to the stages of this relationship, in the 60s, we remember that at the level of the European Union, there were very important decisions regarding the direct effect of the law of the European communities. By the time, the famous decision Wangen and Loss, adopted in 1963. And this decision gave the possibility to invoke the EU law in the internal order, but again in the framework of the legislation of the EU, which is a very complex legislation. So starting with the 60s, the court in Luxembourg start to make definition of the nature of the EU law. First of all, by this very important judgment on the Van Genden laws. Afterwards, by a second judgment that had also very important role because they talk about the nature of the European Union. We talk, this is Costa-Enel. And in this judgment, the court said that the legal order of the European Union is a new international order. So it means that it's not international law. This will be very important for our human rights analysis. It's not international law, it's not domestic law, it's something that it's new, it's a new order. So this is also very important when we talk about the nature of the European Union and also the relationship between the convention and the courts, the two courts and the two instruments that exist. So these were the 60s. As interesting enough, in the 60s also, the first decision of the court in the Storr case was not a decision that was favorable of the application of the human rights. So in this decision, the court in Luxembourg said that human rights have not an application in the law of the European Union. Afterwards, in 70s, it was an interesting development because in cases like of the constitutional courts of Germany and of Italy, like cases like Solange and Frantini, the two courts. The two constitutional courts put a lot of emphasis of the rights, the constitutional rights of their own country. So this kind of dialogue between the constitutional courts, especially the German constitutional court, but also the Italian constitutional court to a certain extent, and the court in Luxembourg will continue. It will be a kind of saga, but this will determine also the European Court of Justice to advance their competence and also to advance the EU law because more that the law of the European Convention was developed by our court. It was enough developed, but more than this, the European Court in Luxembourg played a fundamental role in the development of the EU role. And here we have a very famous expression by Professor Steiner, who said that tucked away in the small ducat of Luxembourg, the EU court had played a fundamental role in the EU development. It means that even if the state, they were reluctant, the court in Luxembourg was very much convinced about the scope of European integration. So after having this kind of reactions from the state, the European Court decided in the first case in Stauder that this was the human rights are general principles of the EU law. It means that with this expression in Stauder, it was a very important step taken by the court in Luxembourg, because once we see that general principle of law, which means principles that are related to the constitutional traditions in every country, became a source of EU law, and not a secondary source, and it is the regulation and other directive and other secondary, but one primary source in the order, in the constitutional order of the European Union, European Community by that time. We have afterwards, we see that with this very important step, we have other cases like Nold that repeated the same principle, but we have the Treaty of Maastricht that, first of all, including the reference to our convention, our European Convention of Human Rights, and of the constitutional tradition. So we see now both. We see that the Maastricht Treaty made reference to both, and followed by the Treaty of Amsterdam that goes into the same direction. As I said before, it was in Nice that the charter was, the EU charter was adopted. Is a very advanced instrument of human rights, and it is a very advanced, having a palette of rights that it's more diverse that our convention. And to a certain extent, if we look to this charter, we can say that the charter was adopted to a completely different era in the human rights, comparing to our convention. And also the charter was adopted to the demands of the EU law. So this was, we have to wait, because there were, as you remember, after the adoption of the charter, they were in the EU a big concentration of what they wanted to be a treaty with a constitutional value. These were the 2003, 2004. It was clear that the treaty will not enter into force. And in 2005, we have the referendum in France and in Netherlands that were against this constitutional treaties. So the human rights that were including there and their values that they were including there have to wait until the European Union have to go to another, in a sense, to reformulate some principles that were in this treaty, and following this thinking after this failed constitutional treaty. It was adopted, the Treaty of Lisbon was adopted in 2009. The Treaty of Lisbon is important in many respects for the relations with our convention and human rights. First of all, we have to say that regarding the Charter of Fundamental Rights, if it was adopted in 2010, it was not compulsory. So in 2009, with the Treaty of Lisbon, the Charter became also among the primary sources equal with the treaty. So it has this constitutional role in the order of the EU law. And second, a very important thing, the European Union has to become a member of the European Convention of Human Rights. So this process, the consultation started between the two courts, the EU and our court, but they look like they were going in the right direction, and this consultation stopped by 2013, and in 2014, at the end of 2014, it was a very important opinion given by the EU court, the court in Luxembourg, which said that for several reasons, one of the reasons they were very difficult to be complained by our court. It is not possible yet to have this EU becoming a member of the European Convention. Of course, this was a very it was a very important thing for the development of the relationship between the two courts, and it was this opinion is very much commented and very much criticized by especially by the academia in the EU law, because there were big expectations that European Union will become a member. Afterwards, our court reacted in a very correct way, I will say, because our court considered that in Advantage versus Latvia, the court came back to the consideration that were in Bosphorus, saying that the two instruments, they offer the equivalent protection. So they give the same place to the EU law, concerning in the field of human rights, and didn't go to the provocation to answer to the question that were raised by this opinion. So the relationship between the two courts started to be normal ones. In practical terms, the two courts, they met every year, and also I think in legal terms, after the Advantage judgment, the court in Luxembourg started also to be more friendly to our court, and in the judgment of Arianoshi and Calderaru, adopted in 2006, regarding the European arrest warrant, where such execution entails of a violation of Article 4 of the Charter, brought about the condition of detention in prison. The court in Luxembourg made a lot of reference to our legislation, to our case law, especially in the case law regarding prison condition and Article 3. This Arianoshi and Calderaru was a preliminary ruling asked by the judge in Germany, and it was related to the fact if a Hungarian, first of all, a Hungarian, then you can execute their detention in their own country in conformity with the European arrest warrant, and the answer of the European Court in Luxembourg in this judgment was that we have to look to how our court had made the characterizations of the prison condition and the pilot judgment that were adopted by our court in the case of Hungary, and afterwards this case was reunited with a case regarding a Romanian, Calderaru, and in Romanian case, and afterwards they have to decide if really the prison conditions are the same. Are enough good, they don't have ill treatment in their own country in order to execute this detention. So we see that it's a strong reference to our case law. We have to say that not all the time, and because I think also that the emphasis, as I said before, it is a different emphasis because we look a lot to the economic rights in the field of the EU law. We have a different case law in the field of the freedom of religion. If we look to our case law in Leila Shahin, and afterwards in SAS versus France, regarding the question of freedom of religion and the symbols of this freedom of religion, regarding the way that we have to wear the burqa in public places, we see that our court was more convinced about the principle of the laicite in Europe, and the court in Luxembourg in Bangui versus Bangui and others has thought in a different way, because they consider that the freedom of religion is interior but also exterior. So they will leave in the field of employment, they will leave the wear of this religious symbol, this burqa in this case. And the question is now, if you look to the same, the question is now to EU citizen, which is also is related to the EU legislation, and to the case law of the European Court in Luxembourg, which has the interpretation of this legislation, and also is looking to the convention to which they are going to apply. The problem is that the individual cannot apply to the court in Luxembourg, only for some action in annulation, because otherwise they have to formulate a preliminary question, and they cannot apply, as I said before, in all the fields, only in human fields that are related to covered by the EU law. So this is the difference between the two of them that said. So we see that we have convergence, and majority of the case law, I think it is convergent, and we have here a lot of our other examples in the field, especially in the field of digital rights, for instance. but we have also some examples where the case law is different, also because the emphasis that is given it by the different court are different. This is a huge topic, and there are books, a lot of books written about it. So I will stop here and wait for the question. Thank you very much. I cannot hear you.
Oh, I'm terribly sorry. Yeah. So I turned it off. Thank you very, very much. It was excellent presentation, very interesting. So far, I have 2 questions to Yuris. I received 2 questions, but again, there is some delay. Colleagues are typing and questions come with delay. So now I invite everyone who still have questions to all 3 panelists. It's last chance for you to submit your questions. So questions to Judge Modak I received so far. The first one relates to the case of Bosphorus, which you mentioned. And the question was if the European Court of Human Rights still keeps the standard which it formulated in the Bosphorus case concerning this presumption of equivalence, or there are some preconditions for development of this presumption by way of dynamic interpretation.
Yes, thank you very much for your question. This was the big question after the opinion, but as I said, the answer of the court was very reflected, and in Alvantish versus Latvia, it is clear that the court keep the same presumption of equivalent effect. So this was the way that the court, I think, answer to what can be interpreted as something that, because also the opinion have some, if you want, very delicate, but some criticism to our system. But our system, the court decided to in advantage not to answer, first of all, to the opinion, and in this first judgment that regarding the regulation of Brussels II, decided to keep the same Bosphorus standard. Thank you very much.
Thank you. And the second question might be a little bit provocative. The Judge Modak, one of the reasons formulated by the EU Court against accession was Article 33 of the Convention that allows interstate applications that go against the heart of the idea of European Union. Which practical steps do you see to overcome this issue?
Yeah, indeed. Thank you very much for the question. Indeed, this was one of the impossible, how to say, impossible objection raised by the opinion. And now, under the Croatian presidency of the EU, the negotiations started again, and we are going to see how these critics will be in a sense taken into account by the 2 parties, because it's impossible that we are going to change the convention. I think that some of this remark, for instance, of the court in Luxembourg was very much was quite criticized in the past. So let's see how the negotiation will go.
Thank you very much. So far, I don't see any more questions. Maybe colleagues are still asking. If you give me 3 minutes, I will briefly reply to the questions that I received belatedly. I don't see the organizers if they allow this or not. And maybe meanwhile, we receive questions to the colleagues. I will group them. Sorry, I now switch into Ukrainian language of the questions. Я згрупую кілька питань.
I'd like to group several questions which I received. I will give quick answers. Ms. Hanashuri, in her explanations, uses the arguments that the qualification of hooliganism can assure easier proving of the case than the articles related to equality right. Another matter which steps have to be priority steps in Ukrainian legal system for the objective of raising the efficiency of review of cases related to the use of hate speech. I'd like to combine these two questions. Yes, the governments do not say that the hooliganism can provide easier proving of the case because this easier proving of the case is not required from them. What is required from them? According to their positive obligations, they have to prove or to reject the existence of these motives on the basis of hate. And so this is the priority task, to stop closing their eyes to some crime related to hate, to stop qualifying it as hooliganism, what is obviously provoked by ethnic or homophobic or some other hate. We have to call the things with their proper names, and this is what we are talking about in positive obligations. And when the applicants state that the government did not fulfill the positive duties because they qualified not according to Article 161, but according to Article 125, in the case which I referred to, the court did not agree with the applicants. The court stated that the problem is not in the qualification of the crime itself, but the problem is that even when we have poor qualification, when we have incorrect qualification, which in itself doesn't take into account this motive, but if the motive is disclosed, this motive can become the aggravating circumstance, even in the absence of qualification according to Article 161. As it was not done, the infringement was in this. It was not about wrong qualification, although the qualification itself did not allow to disclose this. Even in different qualification, this issue was not raised. And another important issue from Mr. Medved, I'd like to answer this. Can we believe that characterized practice of review of ECHR on hate speech as the latent spirit of the participating member states to criminalize the elements of the administrative crimes and social religions and other intolerance? Thank you very much for your question, and immediately I'd like to answer no. No way. You know, we have this trend which is really concerning to me, to equally implement the hardest punishment, to criminalize everything, to put everybody in prison. The spring will come and it will put everybody in prison. European Convention is not about this. I'd like to share with you the word civilization itself. It has many meanings. It came to Ukrainian language from French. And the first meaning of the word civilization in French is the transfer from criminal punishment to civil punishment. That is what we call today decriminalization. The more civilized is the society, the less is the need to go to the strict criminal punishment. This is what we should be striving for. In this case, which I quoted, the European Court stated that the problem was not that it was administrative punishment. In an administrative qualification, an administrative offense, if there is no serious threshold, it is quite adequate if it allows to disclose these motives. It's not about criminalization, no way. It's about proper disclosure of the motives which are staying behind the offense or crime.
Questions, and I think it's time to thank again wholeheartedly my dear colleagues, Judge Bartson, Judge Motak, for first of all, your agreement to come to join us, for your excellent presentations, for your replies to questions. and to all the colleagues who joined us today, who listened to us. And we have now 130 participants listening to us, and I can assure you that much more will listen to us in YouTube. Thank you very much to everyone, and I wish you successful continuation of the forum. Дорогі колеги, всім дуже дякую і до зустрічі.
Dear colleagues, thank you very much and see you next time. Bye-bye. Thank you, Ms. Gada, for great moderation of our fourth session. Now I'd like to announce the break for 15 minutes. At 11:45 we meet again here as we will discuss the problem of execution of judgments of the European Courts for Human Rights in Ukraine.
Mute. Okay. Yeah, you have this mute microphone and start video. Otherwise, there is this icon of interpretation. Okay. You can switch to English in the interpretation page for the question. Where is the icon for the questions and answers? I see mute, Zoom. You are now online. That's not your microphone because you are now online.
Dear Mr. Bakirci, very nice to meet you. Do you need any help with testing the platform? I can't hear. Can you please? Yes, perfect. Okay, do you see me? Yes, I can perfectly see you and hear you. Can you see the on the bottom of your screen the symbol interpretation, share screen? Do you see all the buttons of the platform?
I don't see actually.
On the bottom of your screen?
Bottom of screen, no, I don't see it.
Okay, so
I just see myself in a screen, and
the problem might be.
It says switch to gallery view. Shall I do that?
It won't help. Did you follow just the link and open the Zoom platform? Okay,
Yes.
you need to download the program. Otherwise, you will just see it from the browser, and that's why
yeah, Hassan, it's very...
Okay, I have the program. I have the program. I'll just connect with the program then.
Yep, we will wait. Thank you.
Use the meeting number. I think it's quite easy, and the password. I think they should be there. Marta, can you see me as well? Is it?
I can. Yes.
Okay, excellent. Thank you.
Good day. Yes, very nice to see you.
Very nice to see you too. Thanks.
Thanks. Okay, so you can see everything and you can hear us well.
Отже, вітаю, дорогі колеги і колежанки. Ми розпочинаємо.
So, welcome back, dear colleagues. We start our fifth session of our forum. I'd like to greet all of you on the Human Rights Day and to remind you that our panel, which will be dedicated to the execution of judgments of the European Court for Human Rights, is also integral part of the right for fair trial according to the European Convention for Human Rights. And we will be discussing this today. Some navigation information. Now we will have presentations by Mr. Hasan Bakirci and Mr. Pavlo Pushkar. Why are they united? Because they will be talking about the topic of Burvich case. They will have brief presentations, but please be prepared and ask questions if you have any. Please write them down in the chat. Also in the chat you can share your reflections on what you have heard. And now I suggest that Mr. Hasan Bakirci, Deputy Secretary of the Section of the Chancellery of the European Court of Human Rights, will start his presentation. Please, Hasan.
Thank you very much. Good morning. Thank you very much for giving me the opportunity to contribute to this very important event. This morning, I will be talking about the requirements of Article 46 of the Convention, and more particularly, how this provision was employed by the court in the context of Yuri Nikolaevich Ivanov pilot judgment against Ukraine, which was adopted in October 2009, concerning the systemic problem of non-enforcement or delayed enforcement of domestic decisions. And finally, I will explain the reasons for the court to deliver the Burvich judgment in October 2017, where the court decided to discontinue the examination of these applications and to strike out more than 12,000 applications of similar nature. Obviously, it will be a great challenge for me to do all this in 10 minutes, but I will do my best. So let's start with Article 46 of the Convention. As you know, one of the most significant features of the Convention system is that it includes a mechanism for reviewing compliance with its provisions. Therefore, the Convention not only requires the contracting states to observe, to respect the rights and obligations under the Convention, but also establishes a judicial body, which is the European Court of Human Rights, which is empowered to find violations of the Convention through its judgments, and the states are under an obligation to comply with the court's judgments. In addition, it sets up a mechanism to supervise the execution of judgments, which is entrusted to the Committee of Ministers, which my friend Pavlo Pushkar is going to be talking about. So what does Article 46 of the Convention says? If you have the textbooks, if you read the Convention, if you read this provision, the first paragraph of Article 46 sets out the obligation on the contracting states to abide by the court's judgments. The remaining paragraphs, 2 to 5 of Article 46, set the framework for the procedural modalities to assess the steps taken by a state to fulfill its obligation. Article 46 means that the court's finding imposes on the respondent state a legal obligation to put an end to the breach and make reparation for its consequences. In other words, the contracting states will be under an obligation not only to pay the applicant the sums awarded by way of just satisfaction, but also to take individual and/or, if appropriate, general measures in its domestic legal order to put an end to the violation found by the court and to address the effects. Now, let me turn to the Ivanov case and to see how this provision was used by the court. Those of you who might be familiar with this problem of non-enforcement of domestic decisions would know that the first case arrived at the court in October 1998, a case called Kaisin and others. This case was friendly settled by the parties, and the court struck it out on 3rd of May 2001. However, the court continued to receive many cases concerning non-enforcement of domestic court decisions against Ukraine. The domestic court decisions mainly related to payment of salaries, allowances to military servicemen, employees of the mining company, judges, school teachers, as well as debts of municipalities or state-owned enterprises. As a result of an increasing number of applications concerning non-enforcement of domestic decisions in Ukraine, and after having examined and found more than 300 violations in these cases, the court decided to have recourse to the Yuri Nikolaevich Ivanov judgment as a pilot judgment. So in its pilot judgment of 15th October 2009, 11 years after the first Kaisin case, the court in the Ivanov case first found that there had been a violation of Article 6.1 of the Convention and Article 1 of Protocol number 1 of the to the Convention because of the non-enforcement or delayed enforcement of final domestic decisions. The court identified the national dysfunction in Ukraine and noted that the delays had been caused by a combination of factors, including the lack of budgetary funds, the bailiff's omissions, shortcomings in the national legislation, as a result of which Mr. Ivanov and other applicants in a similar situation were unable to have the judgments enforced. The court also found that there had been no remedy at national level satisfying the requirements of Article 13 of the Convention in respect of Mr. Ivanov's complaints about non-enforcement. In particular, Article 46, under Article 46, the court held that the Ivanov case concerned two recurring problems. One, the prolonged non-enforcement of final domestic decisions, and two, lack of an effective remedy, domestic remedy, to deal with it. These problems led the court to find violations of the Convention in over 300 cases concerning Ukraine, and the Ivanov case demonstrated that these problems had remained without a solution despite the court's clear rulings urging Ukraine to take appropriate measures to resolve those issues. In view of the fact that approximately 1,400 similar applications against Ukraine were pending before the court in 2009, the court asked the Ukrainian government to set up within 1 year an effective domestic remedy to provide adequate redress, and also to grant such redress to all applicants whose applications were pending before the court. Pending on adoption of those measures, the court adjourned the examination of those cases. But recall that it will have no choice but to resume the examination of all similar applications pending before it and take them to the judgment so as to ensure the observance of the convention if Ukraine did not comply with it. Ukrainian government asked for extensions, and the court granted one of them, but then rejected to grant further extensions to carry out reforms. And by February 2012, the court had already accumulated some 2,500 Ivanov-type cases concerning non-enforcement of domestic decisions. So referring to its previous warning that it might restart examining these cases, the court indeed started examining those applications because the court did not see a resolution of the problem at domestic level. These applications were examined in the most efficient manner by use of IT tools or simplified procedural tools. And when we reached 2013, the court had rendered almost 2,500 judgments on this issue. This was a record number of mass processing in the court's history. But the efficiency of the court backfired. The more cases the court examined, the more cases came to the court like a snowball. All in all, the court received from the very beginning, from the Kaysing case in 1998 to 2017, some 29,000 applications. And it delivered judgments or decisions in 14,430 cases. And there were still more than 12,000 applications pending before the court. So the court, after the Ivanov judgment, was faced with a situation where the contracting state, which is Ukraine, was unable or unwilling to enforce the pilot judgment, or the respondent state, Ukraine, had no funds to honor its debt under the just satisfaction awards made by the court. And the court continued to receive huge number of applications resulting from the national dysfunction, which threatened the human rights protection system under the convention. Now, the questions before the Grand Chamber of the court in the Burmich case were therefore the following. What is the meaning of the pilot judgment procedure? What else the court can do in Ivanov-type repetitive cases? And how long more it should continue to deal with these cases? And what are the limits of the court's function under Article 19 of the Convention? So the court selected initially 5 applications, but as part of 12,143 total applications. 4 of the 5 applications, as I mentioned earlier, were about the victims of Chernobyl disaster, and they were entitled to receive various social benefit pensions. As they did not receive these benefits, they went to the court, and the court found them right and asked the authorities to pay their pensions. However, the authorities did not, because of lack of funds, they could not execute the judgments, and the applicants had no choice but to come to the Strasbourg court. So when examining the Burmich case, the court first explained that at the heart of these applications, there was the division of competence established by the convention system between the court, whose function is to ensure observance of the engagements undertaken by the states, but on the other side, the Committee of Ministers, whose function it was to supervise the execution of the final judgments of the court. The court in the Burmich case noted that despite significant lapse of time since the delivery of the Ivanov pilot judgment in October 2009, the Ukrainian government had failed to implement the requisite general measures capable of addressing the root causes of the systemic problem and to provide an effective remedy securing redress to all victims at national level. Since the introduction of these first applications, as I told, the court rendered more than 15,000 applications, and there were more than 12,000 applications pending in 2017. So if the court continued to examine those cases and all the follow-up cases in the same or a similar manner, it would face the inevitable prospect that growing number of applications would, in Ukraine would turn to the court. And the court ran the risk of operating as part of the Ukrainian legal enforcement system and substituting itself for the Ukrainian authorities. The court had to therefore consider how the situation could best be addressed in a way which respected the rationale of the pilot judgment procedure in accordance with the principle of subsidiarity underpinning that rationale. So the court recalled the object and purpose of the pilot judgment procedure, which has dual purpose, 2 purposes. 1, to reduce the threat to the effective functioning of the convention system, and 2, to facilitate the most speedy and effective resolution of this function affecting the convention rights of the applicants in the national legal order. The Ivanov pilot judgment had clearly not succeeded in achieving that aim, and post-Ivanov cases accounted for almost 1/3 of all the repetitive applications pending before the court at that time. And nothing would be gained, nor would the justice be best served by the court's repetition of its findings in a lengthy series of comparable cases, which would place a significant burden on its own resources with a consequent impact on its considerable caseload. Only a lasting solution to the root cause of the problem adopted in the execution process could provide an adequate response to the present situation. So accordingly, the court had to consider whether it was justified to continue examination of Ivanov-type applications having regard to Article 19 and 46 of the Convention. In this respect, the court considered that the legal issues under the Convention concerning prolonged non-enforcement of domestic decisions in Ukraine had already been resolved in the pilot judgment of Ivanov. In other words, the court had discharged its function under Article 19 of the Convention. The Burmic case and all similar 12,143 cases pending before the court, as well as any similar future cases to be submitted to it, were part and parcel of the process of execution of the pilot judgment. Their resolution, including in individual measures of redress, had to be encompassed by general measures of execution to be put in place by Ukraine under the supervision of the Committee of Ministers. Having regard to the respective competencies of the court and the Committee of Ministers under Articles 19 and 46 of the Convention, the court was forced to conclude that no useful purpose was served in terms of the Convention's aims in its continuing to deal with these cases in accordance with the practice hitherto followed. So, the interests of the applicants and all other existing potential victims of the systemic problem in question were more appropriately protected in the execution process. As such, the Convention aims were not best served by continuing to deal with post-Ivanov cases, and therefore the continued examination of the case was not justified within the meaning of Articles 37, 1c of the Convention. So therefore, the court decided to strike out all these applications and transfer them to the Committee of Ministers so that the Committee of Ministers supervises the execution of final judgment in the Ivanov case in cooperation with the Ukrainian government. So this is all I want to say.
Yeah, thank you, Hassan, for your deep review. And now Pavlo Puchkar can continue this topic. Pavlo?
Дуже дякую, пані Лариса. Шановні пані модераторка, шановні
moderator, colleagues, participants of the forum. Thank you. Thanks to the organizers for the possibility to speak today and for organizing this great event. I would like to thank Council of Europe projects as well as OSCE for their dedication to this event for many years, and also thank on behalf of the Council of Europe to the Supreme Court and the Lviv University for participation in the organization. Also, I would like to thank on behalf of the legal community of Ukraine and also Hassan Bakirci for his speech and being consistent in the support of legal education on Convention in Ukraine. Hassan was actually a great influence both in the formation of case law about Ukraine, not just about Ukraine, but also, and we're really thankful actually to him. And I would like also to refer to the statement of Professor Louis Henke that almost all states keep to almost all principles and norms of the international law. Actually, this is also about keeping the debates of international law as cross-sectoral scientific discussion and execution of ECHR decisions. And Hassan already started speaking about it, but I would like to first note that execution of Ivanov and Burmic case decisions, it is especially hard to talk about that, and not because this is an issue which is unclear from legal point of view, but actually because among those who are interested in the convention and court practice, there are no experts in Ukraine which do not understand this problem and the importance. The problem of Burmic and Ivanov, actually, that's already a legal meme. And I would like to present a somewhat unique point of view from 2 points. Why is it important to solve this problem? And what actually can the non-resolution of this problem lead to, from the point of not keeping to international obligations to comply with the final decisions of ECHR? I would like first to come back to history and remember that for many years, lawyers and judges, representatives of legal profession, first of all, concentrated on the court decision as a final stage, doctrinal stage of legal meditation. Execution of court decision was considered belonging to another world, not the world of justice, but the world of the external world, which does not belong to law and procedural law, and therefore the court and the lawyer actually finished their participation in this part of the process. And quite possibly associated with the case that it was about reflection of this origin of the justice. They actually described them as children of higher heavens, but actually with the French Revolution, all ritual and also religious dimensions of court practice were lost, and the rationales what became to prevail. This happened also due to the practice of ECHR, and here I have to recall the Hornsby versus Greece decision. By the way, at the time, Greek authorities only considered the decisions recommendations, and the court decision stopped being just a moral obstacle for the recipient of this decision, but actually it was part of this zone of responsibility of the court. And presently, at this time, it seems that the society needs more than ritual of this, especially in today's hyper-quick informational society, where the demand for service and the service actually have only minutes, if not seconds, passing between them. So this, for the justice services, they also expect specific result, not just the textual decision, but instead money or real restoration of the right. And here the trust in the justice, the understanding of a simple person means, first of all, actually the achievement of the result, not abstract categories of the law. And in this context, the system of the efficient system of the law and court system, which does not generate execution of court decisions, is simply a pretty Christmas toy, but it doesn't generate any interest or even respect towards the producer. Apart from that, when these decisions are not enforced, then the social functions of regulation are lost, as well as the execution of court decisions on the national level has negative impact on the functionality of the international law as the reflection of the system of values, and actually puts under doubt the international law as such as the system of obligations. By the way, about the functions of the right, at the time, actually, Professor Glauter Pach also wrote about that, and Professor Rabinovich actually recalled about him yesterday. It is paradoxical, but the negative experience of Ukraine in executing decisions on Ivanov and Burmich cases actually forms the content of requirements of international law and their rejection of international law to such anomaly as non-execution of ECHR. But in my opinion, actually, this is not the case when there is a silver line to every cloud. The regression in the last 20 years is rather obvious. First, Ukraine does not execute the pilot decision due to the fact that the first decisions in 2001-2004 were not executed. The court also accepts this decision, the decision of the Great Chamber about the implementation of pilot decision. Then Ukraine also doesn't keep to this deadline and does not take the measures envisaged by ECHR decisions and also recommendations of the Committee of Ministers in the Council of Europe in 2004. I have to draw your attention to 3 decisions of the Committee of Ministers from Council of Europe in Burmese cases in 2019-2020. In particular, June 2019, September 2019, and also October 2020, where this case was again reviewed. In all those decisions, the Committee of Ministers of the Council of Europe uses this diplomatic formulation that the measures which are required by the decisions to eradicate the systemic problem were not taken enough to a sufficient extent. And actually, the last decision notes that these general measures which are required by this decision were not taken until the deadline, which was the 12th of October 2019. And here I have to recall yet another graduate of Lviv University, Rafael Lemke, a really classic expert of the law. I can paraphrase the words of his autobiography, how many recommendations from international organizations do we need so that finally we could confirm the existence of this obligation according to international law. Actually, to confirm a rather clear requirement of, and also codified in Vienna Convention, to actually comply with the requirements stemming from European Court of Human Rights. Just recently, Venice Commission also reported about that in its things, and also the recent decision of the Committee of Ministers of the Council of Europe in UCOS is actually an example of this discussion. Presently, possible things and the impossibility to perform this decision, they are already exhausted. And the initial rejections that were in 2017 about the fact that this decision is not supposed to be executed, they have already been refuted, and there are also the reasons for not complying with the decision, and also there is the available strategy which is available and it is going to be studied by the Committee of Ministers in March 2021. And of course, it is clear that the main measures which would be to adopt to these encompassing changes to legislation, actually the changes both to the laws and those implementing these changes, the practical, systemic, and institutional nature, all with ensuring the automatic compliance with these decisions and also creating the protective measures. Unfortunately, these elements are not put in the strategy on the national level. And in the end, just a couple of words. I would like to answer to the question, what next? I have to know that this execution of decisions is a critical component of European Convention. The right to individual recourse to ECHR is actually illusionary, no matter how if, for example, the final decision is not executed. In Ukraine, the provision of Article 55 of the Constitution of Ukraine is also illusionary. And I would like to ask several rhetorical questions in the end of this discourse. So what do we expect next about the when we do not comply with this clear decisions of ECHR? The decision of the Committee of Ministers confirms the lack of general professional measures to execute the decision, but whether will, in this context, the ECHR use the procedure of restoring the proceedings in Burmich case? Does the Committee of Ministers and the Council of Europe, is it going to apply the provision of Article 46.4 about the long, incomplete, insufficient, or partial execution of general measures, which could be the consequences of such decisions for the international responsibility of the country in Council of Europe, in particular on the basis of recommendations of PACE. For example, Ukrainian delegation can be devoid of authority in PACE, or maybe the procedure of statutory responsibility of Ukraine, violation of obligations when joining the Convention on Human Rights. Whether this is going also to be obligations before the EU, we can actually recall the Lawn Agreement, which enumerates the elements of judicial decisions reform, and also the Association Agreement in the segment of human rights. The answers to these questions, due to institutional reaction of international partners, has to be prevented by Ukraine, which has to comply with the decisions of ECHR in Ivanov and Burmich cases, and it has to be done without any further ado. And not just in my opinion, but in the opinion of the European Court of Human Rights and the Committee of Ministers in the Council of Europe. We don't have any other choice. Thank you for your attention. Thanks a lot, Pavlo, for developing what Hassan was already saying. And I'm reminding you that during the speech of the speakers, there was a chance to ask questions to that. And actually, yes, there is a question from Azar. So when do we expect the restoration of case proceeding. And now, Hassan or Pavlo, could you please answer to that question?
Do you want to take it over? Should I reply? Should I try?
Or maybe I can say first that so far we have not received, as far as I know, any request to restore all those applications to the court's list of cases. But even then, I do not know what position is going to be taken by the court vis-a-vis such a request, whether we will be willing to restore all those applications and continue to examine cases concerning non-enforcement of domestic decisions, knowing that the Ukrainian government have not yet fulfilled their duty to carry out a reform in domestic level and to resolve the issue in domestic level in cooperation with the Committee of Ministers. So I don't think that the court's position has changed since 2017. This is my personal opinion. But of course, that needs to be seen, whether there are other circumstances warranting restoration of those cases to the court's list and warranting examination of those cases. Perhaps the execution department might be in a better position to answer to that question. Paulo.
Yes. Власне, у нас та інформація, яка є...
We have the information which is available to the Council of Ministers, to the Committee of Ministers of the Council of Europe. It's the information that the government submitted the motion to extend the term set forth by the court judgment on October 12, 2019, and the Committee of Ministers responded to this in their decisions. It was quite consistent to extend this term, and this request for information from the governmental authorized person was submitted to the European Court for Human Rights. At the moment, we don't know if really this information is reliable from our perspective, because the departments have not seen this request, but in principle this information was declared. That is, now we are not aware of the development of events on this, and maybe it is quite difficult to forecast anything in terms of in what way will the court act going forward in terms of extending the term. From our perspective, the process of execution is not over, and I fully agree with Mr. Hassan. And once again, this is my personal opinion, that in this situation it is difficult to talk about the restoration of review of applications in the European Court of Human Rights. Thank you, Pavlo. Let us move forward, and I am pleased to invite to take the floor Roman Kubida, the candidate of legal sciences, the expert of the Project of Council of Europe related to Article 6 of the European Convention of Human Rights. Please, Roman, the floor is yours. Good afternoon. Greetings to all of you on the occasion of Human Rights Day. Today I'd like to dedicate my short presentation to the case which probably has no other decision of the European Court of Human Rights which would have such strong impacts on the legal system of Ukraine. I mean the case of Alexander Volkov versus Ukraine and the derivative two cases, Kulikov and others versus Ukraine, and Denisov and others versus Ukraine. Or just Denisov versus Ukraine. What are we talking about? The judgment on this case, on this group of cases, affected the significant changes in the legislation. We're talking even about constitutional changes related to the guarantees of independence of judges and disciplinary responsibility system. And certainly there are some changes related to the practice, to the case law. Regarding the positive changes, I would like to notes that after this case, based on my observations, the judges started to understand what is European Court of Human Rights, and European Court of Human Rights is somewhere in Strasbourg. This is the point that judges sometimes used in judiciary proceedings when one of the participants said that I will complain to the European Court of Human Rights. Now, the judges themselves felt that European Court of Human Rights may be the institution in which they have the chance to protect their rights if they cannot do it within the national system. As regards the derivative cases or sideline activity of the European Court of Human Rights, I believe that the communication which appeared after this judgment influenced the absolutization of the principle of independence of judges. Yes, indeed, the European Court of Human Rights stated the violation related to independence of judges. However, at national level, all discussions were focused on this. So this absolutization led to the situation when we had the greatest scandalous decision of the Constitutional Court of Ukraine on e-declarations on responsibility for false declarations of assets in Ukraine. This decision with referral to international standards actually created new provisions which seemingly follow from the principle of independence of judges. However, yesterday the Venice Commission published the urgent opinion produced upon request of the President that in this decision of the Constitutional Court there was no international legal basis, and the arguments they used on absolutization of this principle of independence have no ground in the international standards. So, in fact, we can see this in the last opinions of the Venice Commission. We should be speaking more and more about the balance of independence on one hand and accountability on the other hand. The principle of independence cannot substitute the accountability of the judiciary. What we talk about in the group of cases of Volkov, what is the offense? What is the violation? There was a violation of independence of the Supreme Council of Justice. In particular, in the composition of this council, the minority of judges, and those who took part in accusations, they participated in decision-making, and even at the following stages in the parliament and so on. Similarly, there was the issue of independence and unbiased nature of the parliament when they reviewed the matter of dismissal of the applicants. Non-personal voting, the issue of proportionality of disciplinary punishment and this system of disciplinary punishments, the sufficiency of review of the case by the court, how the court responded, and on that case the court did not respond to important arguments of the applicant, and the issue of independence, impartiality at the stage of case review by the court. These key problems were in the case. If we look at implementation of this decision, of this judgment, and the key positions of the European Court of Human Rights, which are reflected in this judgment at the level of the law, we can say that it was the model implementation of all these things. Almost all problems that were stated were resolved, at least at the level of the legislation. The changes were made to Constitution on the composition of the Supreme Council of Justice. The majority are the judges now. The number of laws were adopted which responded to the problems stated there. The law on restoration of trust to judiciary in Ukraine first, then the law on fair trial right, and the law on judiciary and status of judges in the new version, the law on Supreme Council of Justice, the recent law 193, it also had some influence on the system, although partially it was the step backwards in the issues related to disciplinary responsibility of judges. However, if we talk about practice, the practice of implementation of all these changes demonstrates that the problems in the issue of discipline of judges, accountability, and independence in practice, they remain. For example, in practice, although formally as part of Supreme Council of Justice, most judges are elected by the new system of forming the Supreme Council of Justice, proves to be favorable for different political impacts, and this body it's promoted the corporatization of this body in the negative meaning of this word, when corporate interests unfortunately overwhelm the social interests, the public interests in terms of justice. For example, there are data confirmed by the decisions of the Supreme Court, which show that Supreme Council of Justice does not always follow the requirements of impartiality when reviewing the cases, reviewing the issues. Although the legislation improved at the level of legal regulation, we can say that disciplinary practice today, based on different studies, is not consistent enough. There are deficiencies in justification of decision and proportionality of sanctions. Often, for similar offenses, different sanctions are applied. For more severe offenses, there are easier sanctions which are not related to loss of position. And for easier offenses, sometimes the judges are dismissed from their positions. In many cases, the conditions are created to avoid the disciplinary responsibility. Also, there are no clear landmark in which conditions the disciplinary complaint will be reviewed and in which conditions it will not be reviewed, and what is the behavior and in which way there will be punishment. And it depends strongly on subjective factors, on which member of the Supreme Council of Justice gets certain complaint. And also, we have to note that the degree of thoroughness of research of circumstances in each specific disciplinary case is different depending on the member of the Supreme Council of Justice. Also, the European Court of Human Rights pays attention to the problem of loop dependence, that is, the judges who review the decisions of the Supreme Council of Justice are in the area of disciplinary jurisdiction of the Supreme Council of Justice itself. And earlier, there were no grounds to talk that this is the problem in practice. At least there were no external signs of this. However, this year we had the situation which confirms that there is some problem here. In particular, the Cassation Administrative Court, as part of the Supreme Court, reviewed a case on access to public information and recognized the violation from the Supreme Council of Justice, which did not provide this information. This decision was not executed. So the court, based on the initiative of the applicant, obliged the Supreme Council of Justice to submit the report on the execution of this decision. But this report was not submitted, so the applicant initiated fining the chairman of the Supreme Council of Justice for failure to submit this report. The Supreme Council of Justice, in this case, the representative announced to the all judges recusal, because judges with their decision intervened into the activity of the Supreme Council of Justice as the administrator of the information. The court rejected this recusal, but the judges recused themselves, because the Supreme Council of Justice, when they contested the decision in the Great Chamber, the judgment obliged to provide information, they filed the motion to, at the same time, to do the evaluation of the actions of judges in the form of separate decision of the court, and this may be the grounds for holding judges liable according to the disciplinary liability. So the Supreme Council of Justice is trying to influence, to use its disciplinary functions to get some result in the court. So this problem, this example shows that the problem has the characteristics to be manifested in this form at least. The issue of what still remains unfulfilled, it is, these matters are mostly practical, and now it is very important to overcome the gap between provisions and standards built into the legislation and real practice. In particular, it is important here, and the Venice Commission confirms this. It is important to reach not only formal changes in the procedure forming of the Supreme Council of Justice, but to make sure that the candidates and members of these bodies of the Supreme Council of Justice and Supreme Qualification Commission as judiciary bodies, governing bodies, they should be compliant with requirements set forth for the activity of these bodies. First of all, this is integrity requirements and establishment of the competent authority, which would do the verification of compliance of the current members of the Supreme Council of Justice and so the future members in terms of integrity and professional ethics. This is the important task at the moment. So the Venice Commission, by the way, confirms that this mixed national and international bodies for solving this special situation related to the problem of integrity. They should exist, they should have these powers, but there should be clear time limitations. It is temporary measure to adjust, to correct the situation related to the problem of lack of integrity of some members of the Supreme Council of Justice. Also, the Venice Commission emphasizes that in the civil society, there has to be the role played by the civil society, advisory role in particular, in developing the bodies of judiciary self-governance. Also, it's important to review the procedures of disciplinary procedures, from improving the justice and efficiency to set the realistic terms of disciplinary procedure, the terms of getting the explanations, of sending subpoena, which should be sufficient for proper preparation for the appropriate case. We can see that the practice of the Supreme Council of Justice is very diverse. Some cases are delayed for a long time without justification. Some cases are reviewed quite quickly. I would even say sometimes untypically quickly. To ensure the consistent and foreseen disciplinary practice, we have to generalize the judgments on disciplinary cases by the members of Supreme Council of Justice and by the disciplinary chambers in order to clearly understand how some actions should be qualified and what sanctions should be applied given the principle of proportionality. Also, we have to clearly formulate the indicators which exclude the disciplinary procedure in order for the person who files the disciplinary complaint deals not with the lottery like it is now, but there should be foreseen behavior of the Supreme Council of Justice. My final point is that the matter of judiciary independence, independence of judges, are the issue of annual report on the independence of judges. This is the official report produced by the Supreme Council of Justice according to the law. However, also representatives of NGOs decided to develop the alternative reports. And we can see that the Supreme Council of Justice focuses attention on the external independence of judges, independence from the bodies outside of judiciary, while the problems of internal independence in the view of NGOs are as important or even more important for the judiciary when the judges are dependent, when they use the guarantees of independence, the legal guarantees of independence of judges in order to stay in their positions. Unfortunately, this has the opposite effect, and it creates the grounds for imagining by the society that in the judiciary system there is the corruption. Thank you.
Thank you, Roman. I'm reminding everyone that there is a possibility to ask questions. So now you can actually ask them in the chat. And now I give the floor to a lawyer, head of the Committee on Free Legal Aid, Alexander Drozdov. Are you there? Yes, I'm there. Hello. Thank you for an opportunity to participate in the discussion. And apart from being a member of the Committee of Free Legal Aid in the National Association, I'm also the president of Ukrainian Law Association and an expert of the Council of Europe on applying Article 6 of the Convention, a national expert. I hope, actually, I heard a lot of messages from Roman about lack of integrity and all that. I also hope that I'm going to read some arguments in his report. Also, I would like to thank the Council of Europe, OSCE, and all other stakeholders for the possibility to participate in this discussion and for creating a great and powerful platform for exchange of opinions. As a well-known physicist actually said, that quite probably we have to pass from discussion to the dialogue. And I'll say yet again that all these things that Roman has just quoted, I'll find in his report, and of course we're going to analyze them as well. But actually now I'd like to say a couple of words about what we worked on with the representatives of Council of Europe and discussion of the annual report about the independence. Actually, I'm going to voice several key recommendations were there, and now we're preparing a final report, which is in the discussion of respective stakeholders. So if you allow me just very quickly. So I would like to draw attention to the community that actually my colleagues and representatives of the Supreme Court translated the ballots of ECHR, informational ballots, independence of a system of justice, which has been spread to the resources. And I think that we are going to find out much more and all that. So now I would like to come back and say a couple of words to those recommendations which were there during rather interesting discussion of Supreme Council of Justice. Well, first of all, we pay attention to the fact that actually during these consultations and annual report, we have to involve as many stakeholders as possible, also including the representatives of specialized professional community, in particular National Association and all that, which presently feel themselves, and not from the point of media that they heard or saw something, but actually on themselves, they feel how the system actually works, whether it is dependent or independent, if it is independent, whether it corresponds to the status of the charter or to the consultative commission and all that. So actually involving as many as possible, stakeholders, as many as possible, we actually paid attention to the conclusions of the council, in particular about judges and lawyers, and also the conclusions in 2015 and all that. Of course, in such great community, I don't think that there is really a point to actually pay even more attention to all that. Then again, during our discussion, we paid attention to the fact that there is actually the need for state support, and also with the more attention of the media to form the recommendations, to promote the recommendations of the annual report. So here, during the recommendation and discussion, really it was said that we have to finalize not only the external, it was actually sounded and said, but also the internal independence, which is actually confirmed during the discussions. And also the annual report has to be disseminated as wide as possible, and an official resume has to be provided. There were also proposals to actually stipulate legislative level the efficient actually about making any changes to the legislation, in particular through consultative conclusions. First of all, this pertains to not efficient financing of the system in the pandemic, the lack of judges, intervention in the activities of judges. And by the way, now we also have a rather interesting example when counter to the charter and also the conclusions of consultative thing actually bringing up all that. And we see that actually talking to this actually takes place with the violation of these requirements, because the very changeability of this actually testifies to the fact that it actually undermines the basis of independence, and the judges are now in the situation of not being decided, which actually impacts the quality of justice in Ukraine. And we also have to talk about that. So in particular, a consultative conclusion of the higher conclusion about all that, it has to be included. There should be special telegrams of the Verkhovna Rada, so at least there would be an obligation to review these conclusions. Of course, it is a legislative institution, a political one. It can agree or not, but still, I believe that this is a there is rationale there. Also, I would like to say that on the legislative level, what we discussed, and also those cases, Pavlo Pushkar was also named that, and actually, in case of withdrawal of judges and justice, the legality of the appointment and independence of lawyers who participate in the legal process with regard to ECHR practice. And here there were also decisions voiced, not just Ukrainian. For example, Sanjelika versus Lithuania, Bagirov versus Azerbaijan. The Great Chamber of ECHR also actually other cases. Also what's interesting that the Higher Council of Justice in its annual reports has to clearly indicate the problematic issues due to which they remain unexplained, and it has to contain a list of specific recommendations which further on have to be directed towards the resolution of these problems. What's also interesting, in my opinion, is that in the aspect of executing the decisions. So today and yesterday, I mean, there were lots of things said about the need to comply with these decisions, both individually and generally, but it was said during discussion that we should take respective measures about ensuring the guarantees from this dismissal, or, for example, illegal bringing pressing charges against judges with regard to the provisions in the conclusions of Consultative Council, in particular number 18 of 2015. And also there was attention paid to the cases already referred to, like Salo versus Ukraine, Miroshnik versus Ukraine, Zubko and others versus Ukraine. And also there was a decision, Baka versus Hungary, recalled. Unfortunately, we face the situation that this so-called hate speech about judicial power. As for the freedom of speech, also that was about the discussion and also the respective platform, the Council of Europe. It was about the following, actually about this freedom. They had to take into account relevant practice of Strasbourg Court, in particular in the aspect with the possibility of the judge to freely comment political events. Actually, it is also said in the conclusion of Consultative Council of 2015. And also it is associated with the judicial reform. It is not just Baka versus Hungary, but also Kudeshkina versus Russia. So here we have to talk in this context about ethical aspects of Article 6 and 10 of the Convention, because the coverage of judicial process by lawyers or journalists or bloggers or some even civil activists, it has to remain within moral and ethical principles of professionality. It has to be founded on certain facts. By the way, unfortunately, this is lacking from the point of some civic organizations when they say that this is some hate or whatever. You have to provide facts, and then we're going to say that such events actually did take place. And it is true that a single fact can testify to a systemic problem. It can testify to the fact that, there is a problem which requires detailed analysis and solution. Also, it has to be founded on explanation of legal content of the decision. In the context of guaranteeing adequate payments of remuneration to the national judges, there was also attention paid to the decision I brought up, Zurko and others versus Ukraine. And now about the cases of intervention in the activities of the judge, or to the recommendations. We can agree to them, or we can be critical about them, but they were still said. This would be the introduction of more systemic monitoring of results or efficiency of reacting to respective subjects, and also to take measures about protocols to administrative liability for not providing this, and also to ensure certain administrative violations and all the like. Also, what I would like to pay attention to, not to take too much of your time, actually today we have some problems when we actually Article 370 loses its force, which was considered unconstitutional by Constitutional Court of Ukraine. By the way, coming back to the decision of the Venice Commission about the Constitutional Court of Ukraine of 27th of November 2020, then Venice Commission actually indicated the decision of the, and still it doesn't testify to the fact that there should be no respect towards this constitutional jurisdiction. And no doubt we have to take measures, and these measures, let us say, quite possibly the unconstitutionality of one decision should not cause unconstitutional cases due to this subject, but of course the Venice Commission actually pointed out the Constitutional Court went beyond its scope, but still this does not give the right to act unconstitutionally, but be based on those provisions of the Constitution which are envisaged in our main law. So to improve the activities, and actually it was recommended to introduce the system of permanent monitoring about law enforcement actions in criminal proceedings, and also interaction with the Prosecutor General's office to develop a special training course for the prosecutors to study problematic issues of action and inaction of prosecutors which negatively impact the independence of courts. And we know that according to the national law on implementation of ECHR decisions, one of the measures is actually joint training, during which the relevant decisions are going to be there. And also there was, it was said that actually to cover information by journalists, also we could offer cooperation for journalists. And in the end, I would like to pay attention to the fact that actually the problem of judges' independence cannot be reviewed only in the context of specific court or judicial implementation or judicial self-governance, because it has to be looked at in a comprehensive way. And it is based on this, this approach that a range of international documents stress on, and the European Court of Human Rights in particular. Thank you for your attention. If I took too much of your time, I'm sorry. Yes, Alexander? Yes, you took too much of time, that's true. I'm just reminding everyone that actually the right to comment doesn't mean almost, it cannot be equal to the main report. So I really ask Roman in 2 minutes to answer the question. I see that you're in the chat, you already answered one question, but still there is a second question, which is about methodological role that can be played by Alexander Volkov's case for the balanced understanding of conflict of interest by Constitutional Court judges when reviewing cases. So I'm asking you to answer that question, and then you can also react to the question above. Thanks a lot for this question. I talked to foreign counterparts and I asked them about the impressions about the decision of Volkov's case, and they were impressed both by what Judge Volkov actually said, that is was also the approval of the decision with certain conflict of interest, the review of the case, like solving that it was a case which was reviewed by the relatives, and also just the same, were impressed by the actions of representatives of some law enforcement and members of Higher Council of Justice, which, among other things, were also participants in solving this issue in the parliament. But I think that, yes, this decision can be very instructive, but even more instructive should be the yesterday's conclusion of Venice Commission about a conflict of interest, where this issue was looked at, about how transparent and how actually they kept the procedural guarantees during the approval of this decision of the Constitutional Court that we have been talking about recently. That is the decision in the case on the Authority of National Anti-Corruption and all that. So the problem of conflict of interest becomes even more and more relevant, because now more and more often we face the examples when a decision is made by authorized institutions with the participation of members who are actually in the conflict of interest. And actually these claims are put towards Higher Council of Justice by NGOs as well when they look at the issues about disciplinary liability of justice. Thank you. Okay, Roman. Also about declaration, just that not everybody can read the chat. Could you simply repeat your answer about maybe it should be better to transfer this justice, which is not under the aegis of that it should be under self-government of judges? Well, in my opinion, creating a separate system for submitting declarations, I mean, there is no need for it. And even taking resources into account. I mean, there is a single declaration system, which is absolutely normal, which is totally according to the practice of various countries. And I mean, the only thing that we can talk about now is here that there are some clarifications in the mechanisms of monitoring of the state and compliance of the state to those declarations that have been submitted. I mean, the Venice Commission yesterday proposed a range of alternative options which could be there that would be improving the independence with the higher public control and also participation of judicial governance bodies in the control over these functions, and also providing the authority about the monitoring to the High Qualification Commission of Judges after it is going to be created according to the recommendations that the Venice Commission provided before. Okay, thank you, Roman. Presently, I'm finishing this part of our today's 5th session. I'm reminding you that we're going to meet at 1 p.m. We are somewhat actually shifting, and our first speaker is going to be Nazar Kuczynski, and actually we are going to talk about general measures. So please prepare your questions, and we are going to meet at 1 p.m. Thank you for your attention.
Вітаю, колеги. В нас сьогодні дуже короткі перерви.
Greetings, colleagues. We have very short breaks, so we would like to do many things and hear everyone. I'd like to give the floor to the lawyer Nazar Kolchinsky, Vasilkis and Partners. Silka versus Ukraine, the plan of general nature measures. Please, Nazar.
Як на мене, ця тема у нас сьогодні є дуже актуальна, але те, що я ще хотів звернути увагу, насправді на всіх попередніх форумах в частині там виконання рішень Європейського суду були представники ВНЮ. Як на мене, сьогоднішня відсутність будь-кого взагалі з Мін'юсту в цій панелі, як на мене, свідчить про те, що міністр не має що сказати,
nothing to say, they don't want to say anything.
В жодному випадку не звинувачую
колег. I'm not accusing our colleagues from MOJ. I know how it looks like. I was there myself. MOJ may initiate things, but final decision is not made by MOJ anyway. I believe they have nothing to say because the government is not willing to resolve this matter. For example, on the case Ivanov and Burmich, it was mentioned that this government is not doing anything to fulfill these decisions. But if we take Butkivsk-Kontrabot, the case versus Ukraine, we can demonstrate that there is activeness of the state, but it's in the wrong direction. It's not what is expected in terms of execution of judgments of ECTHR. For those who are not familiar or forgot, I'd like to remind you that Butkivsk-Kontrabot case is about depriving the property rights of the applicants. The applicant is the charitable foundation which deals with rehabilitation of children, orphans, and children from vulnerable families. And back in 2002, they purchased the property which belonged to the trade unions in the past, to the company under the trade unions. And during the long period of time, the prosecutor's office had a war with them, and as a result, they were deprived of the property right for this result, and the justification of the prosecutor's office and the state was the reference that the state remains the only legal owner of this property, and this property never belonged to the trade unions or to the companies or trade unions, and they had no right to sell the property to the applicants. While before that, in the 1990s, there were legal disputes on this matter, and actually, the High Arbitration Court ruled that trade unions are the legal owners of that property. Still, in 2014, this property was taken away. What is the peculiarity of the case? This situation is not one-off situation in Ukraine. This is not the case of one applicant. In this case, since point of independence of Ukraine since 1991, the General Prosecutor's Office has directed hunting for all the property which used to belong to the trade unions. And at different times with different success rates, they applied to national courts with lawsuits to declare the agreements null and void and to return the property to the state ownership. And the main grounds was mentioned as that in 1991
проект закону про майно підприємств і колишніх закон України про підприємства, установи і організації союзного підпорядкування, що розташовані на території України. За цим законом нібито було заборонено продаж майна профспілок, яке належало колишнім союзним профспілкам, до врегулювання питання щодо права власності на них. З того часу ніхто більше нічого не приймав, і фактично це було
practice was the main argument on the private and the property rights. The European Court, in their judgment on the case Батьківська турбота versus Ukraine, noticed that the claims of the state are very dubious for this property. The court actually put in doubt the right of claim of the state for this property, not talking about the second argument related to the fact that this happened more than 25 years ago, that this matter has been solved by the courts and so on. I'd like to draw your attention that the court puts in doubt the right of the state to claim for the property of the trade unions. However, for the applicants, this had successful ending. The Supreme Court, having reviewed the rulings of the courts of lower instances, and as a matter of fact, they restored the satisfaction of the claim and they returned this property to the applicant, to the charitable foundation Батьківська турбота. However, within the execution of measures of general nature, the state had to stop this hunt for the property of the trade unions. And as a matter of fact, this property used to belong or belongs to the trade unions now, because most of this property now belongs to the private entities, which are good faith beneficiaries, but as a result of these actions of the prosecutor's office, they are deprived of their property. In terms of measures of general nature, I believe that everything is quite simple, as it was mentioned by the classical artists. We have just to stop filing this action to the national courts. This is the case in which we don't need to reinvent the bicycle. We don't need to adopt the draft law. Talk about Burmish and Ivanov case. Everything is about money. The state has to pay money, and the state doesn't like to do this with any government. The state does everything to make sure that it doesn't repay money. In this case, we don't need any expenditures in the state budget. We don't need any difficult changes. We just have the position of the European Court. We have the provisions of the national legislation according to which this practice is absolutely illegal, and we have just to stop inventing the grounds for restoring the term of statutes of limitation and other reasons to apply to the courts. And the measures of general nature should stop filing unsubstantiated and illegal actions. However, the state does not stop its attempts. And the bright example of this is that after the decision in the Батьківська турбота case, the draft law was developed, which had very positive name, draft law on making changes to the law on trade unions and guarantees of their activity. And one of the provisions of this draft on guarantee of the activity of the trade unions was suggested to recognize all the property that belonged to the trade unions until 1991 as the state's property. As a matter of fact, over 30 years, the state decided retroactively to deprive an unknown number of legal entities and natural persons, individuals, trade unions, their companies, to deprive all these entities of their rights, property rights. The execution of the judgment on Батьківська турбота case was mentioned by the Minister of Justice.
Щоб не помилитися, 11 грудня 2019 вони подали план заходів, в якому зазначили, що в даному законопроекті дійсно є якісь норми, які можуть суперечити висновкам суду. Вони дали рекомендації, розробники врахують ці рекомендації. Фактично, після цього цей проект закону був відкликаний з Верховної Ради. Але щастя не тривало недовго. І вже 27 вже грудня 2019 року за авторства депутатів від «Слуги народу» зайшов
the MPs
новий
from
проект
the Soviet of the
закону,
People faction
який
submitted the new
також
draft law,
містить абсолютно загальну
which
назву
contains
про
which
внесення
has
змін
general
до деяких
title changes to some
законодавчих актів
legal
України
acts of
щодо
Ukraine
діяльності
on the
профспілок,
activity of the
великий
trade
закон,
unions. It's the
багато
big
букв,
draft,
які стосуються в
many
основному трудового
letters on
законодавства,
labor law,
організації
mostly on
роботи
organization of
профспілок і
work
так
of the
далі, і
trade
так далі.
unions and so
Але за
on.
класикою жанру
However,
в
it
нас
is
йдуть
classical.
прикінцеві
We
положення,
have
якими знову
final
ж таки
arrangements
пропонується
which once
визнати
again suggest
державною
to
власністю все майно,
recognize state
яке
property, all the
належало
property
профспілкам
which used to
чи
belong to trade
підприємствам
unions or
до
their companies
91-го року. Тобто,
until
знову ж таки,
before
пропонується
1991. Once
націоналізація
again,
без надання
nationalization is
будь-якої
suggested without
компенсації
any
чи
compensation
профспілкам і їх
to the
підприємствам,
trade unions or
чи
its companies
приватним
or to the
власникам, які
private
станом на
owners
сьогодні
who,
є
as of today,
добросовісними
are
набувачами цього
good
майна,
faith
про що сам
acquirers of
Мін'юст
this
пише
property, which is
в
mentioned by the Ministry of
своєму плані
Justice
дій.
in their plan of action.
Крім того, станом на сьогодні залишається
As
велика
of
кількість
today, we
позовів
still
органів
have many
прокуратури
actions of
в
the
судах
prosecutor's
всіх
office in the courts of all
інстанцій,
instances
юрисдикцій
and
про
jurisdictions
повернення такого майна в
returning
державну
this
власність. Але
property
насправді
into
це
the state
ще
ownership.
не все.
However, this is not
Фактично
all.
цього для виконання рішення
In
справи
order to fulfill the
Батьківська
judgment on
турбота проти
Batkivska
України державі
Turбота versus
здалося
Ukraine
мало.
case, it was not,
І тому
state seemed that this is not enough. The state believed this is not enough.
Вже в цьому
This
році,
year,
в вересні
in
2020 року,
September
Офіс
2020,
Генерального
the General
прокурора
Prosecutor's Office
порушив кримінальне
initiated
провадження
the criminal
за
proceeding
фактом
on the
привласнення
facts of
посадовими особами
embezzlement by the senior officials of the trade unions of the state property in significantly big amounts.
Генеральна прокуратура станом на сьогодні говорить,
The
що все
prosecutor's
майно
office is
профспілок
saying that all the property of
воно
the
було
trade
незаконно
unions was
привласнене.
illegally
І в нас
embezzled.
виходить абсолютно нелогічна і
We have
нездорова
illogical and
ситуація.
unhealthy
Європейський
situation.
суд
The
говорить
European
про те, що у
court is
вас
saying
відсутні
that
правові підстави
we
для
don't have
того, щоб
legal
навіть
grounds
претендувати на це
to
майно.
claim for this
А
property.
Генеральна
And the
прокуратура говорить,
prosecutor's
що
office
той
is
факт, що
saying
це
that
майно
the fact
опинилось
that
в
this
власності
property ended up in
профспілок
the ownership of
є
trade
сама по
unions
собі злочин.
is the crime
Звичайно
in
ж, це
itself.
частина 5 статті
This is
195
Part 5 of
першого
Article
привласнення
195,
державного
the
майна в
embezzlement of
особливо
state
великих
property in
розмірах.
significantly big
І,
amounts. And
що саме цікаво,
what is the most
вони на
interesting,
цьому не
they
зупинилися.
don't
І
stop
3
there.
листопада
And
цього
on November
року
3rd this year,
за клопотанням
based on the motion
прокуратури
of the prosecutor's
4
office,
ухвалами
there were
Печерського
4
районного суду
decisions of the
було
Pechерsk District
накладено
Court
арешт на
which
26
arrested
об'єктів нерухомості,
26 properties,
які належать профспілкам,
freeze 26
їхнім
properties belonging to
підприємствам,
the trade unions and
або
their companies,
коли-небудь були в
or
них придбані. І станом
which
на
were
сьогодні
purchased
більше
from them
половини цих
in some period
об'єктів
of time. And more than
нерухомості
half of
належать
these properties
приватним
now
особам.
belong to the individuals, to private
Фактично,
individuals.
цей арешт було накладено в рамках
Prison order
даного
was
кримінального провадження.
rules within this criminal
Арештовано
proceeding.
воно все було, звичайно, що
It was
речові докази у кримінальному
frozen
провадженні,
as
що вони
the
можуть доводити
evidence in the criminal
абсолютно
proceeding.
незрозумілим.
What's
Так само
can is prove it's
абсолютно
not clear at all,
очевидно
and it's
незаконним
also
є
obvious that
накладення цього
there is
арешту. Тому що
illegal
в 2020 році
issued in this case
було
because
порушено
in
кримінальну
2020 the
справу
criminal
за
proceeding was
подіями
initiated based on the events
29-річної давності.
which
У
happened
нас
29 years ago.
притягнення до кримінальної
Our
відповідальності 15
our
років.
status of limitations for criminal responsibility is 15
Абсолютно
years.
очевидно, що це кримінальне провадження не має жодної
It's
судової
clear that
перспективи.
this criminal proceeding has no
Абсолютно
judiciary
очевидним
prospect. It's quite
є те, на мою
obvious,
думку, що Генеральна
in my view,
прокуратура
that the
просто
prosecutor's office
втомилась
is just tired
ганятися за
to
окремими
run
об'єктами
after
нерухомості.
separate
І вони
properties,
просто
and they
вирішили
just
одним махом
decided to do it
арештувати практично
in
там
one strike.
найбільш
They decided
желательні для них
to freeze the
куски
most
цієї
desirable
нерухомості.
properties.
І
And
фактично було накладено
as a matter of
арешт на
fact,
це
they
майно.
frozen these
Який
properties
буде сценарій руху
altogether.
далі,
What is the
я
from the
думаю,
scenario from
побачимо. Я
here
не
we'll
виключаю,
see.
що до
I'm
деяких
not
приватних
excluding
власників
that
прийдуть
some private
зацікавлені
owners will
посередники,
be
які
visited
запропонують
by
вирішити це
intermediaries
питання на
and
комерційній
they would offer
основі.
to make a deal.
Або не виключаю інший варіант,
Or
який
there
мені
is another
здається
option which I
дуже
believe
ймовірним.
it's
Це
highly
те, що
likely
фактично
that
станом на сьогодні
as of today,
Генеральна прокуратура
the
буде
General Prosecutor's
просити
Office
передати це
would
майно в
request to
управління
transfer this
Агентству з розшуку і
property
управління активами.
to the Agency of
І фактично
Asset
в такий
Management and
спосіб це
Asset
майно
Tracing.
буде
And in this way, this
забрано
property will be
в
seized
власників законних,
from the legal owners,
їхніх
trade
підприємств,
unions,
так і
and their
приватних осіб.
companies and
А в
private
подальшому
individuals.
може бути
And
декілька
going forward,
варіантів
there are
розвитку
several
подій.
options of development of
Фактично,
events.
або
As a
це
matter of
майно
fact,
буде
this
залишатися в
property
управлінні
may
армії
remain
абсолютно незрозумілий
in the management of
період
asset
часу,
tracing and management
або є і ще
company for
один
some
варіант.
unclear period of time, or there is another
Фактично,
option.
арма може продавати
Arma
майно,
may sell the
яке
property,
занадто
as management
дорого
company can sell
отримав.
property which is too expensive to
І я не
maintain.
виключаю, що в такий
As
спосіб
I'm not
будуть
excluding that
намагатися
in this
обійти
way they
необхідність
will
ходити
try
в
to
суди,
bypass the need to go to the
доводити
courts
свою
to
правоту і
prove
так далі,
that
і
they're
так далі,
right and
просто
so
на
on and so
підставі
forth,
ухвали
just
слідчого
on the
суду
basis of
передати
the
в арму. Арма вже
order of
там
the investigative
розпорядиться на
judge to pass
власний
it to asset management
розсуд
company. The asset
цим майном.
management company will just
Відповідно,
dispose the property
ще
based
раз
on their
кажу,
discretion.
ситуація
Once
досить
again, the
проста.
situation is quite simple.
Заходи, які
The
потрібно
measures
вживати
which should be
державі, дуже
taken by the
прості,
state
не
are very
робити нічого.
simple, not to do anything.
Але держава
However,
активно
the state
продовжує
actively
напосідатися
continues
на власників. І
to
таким чином, на мою
attack the
думку, там
owners.
знову ж таки діє
And once again,
чітко
the actions
проти позиції Європейського
are
суду
against the position of the European
і
Court,
тільки поглиблює
as they
дану
only
проблему.
deepen this
В
problem.
принципі, я буду закінчувати, бо інакше я
This
потім 20
concludes my
хвилин не впораюся, як
presentation,
я піду
otherwise I will
далі.
not fit
І
my
готовий
20 minutes if
відповідати на
I
питання.
continue, and I'm ready to answer your questions. Thank you. Thank you, Nazar. Please pay attention to the information from Pavlo on the representatives of the Ministry of Justice and their presence. Pavlo made a summary on the business of the representatives of the departments in the Ministry of Justice. Please, colleagues, do you have any comments or questions to the speaker? Please, you can raise them at this point, because so far I don't see any questions in the chat or in the Q&A section. You can formulate your questions now. Hopefully we'll have a chance to go back to this later, and Nazar will have a chance to answer the questions in the chat if there are any. And so we will move forward, and I give the floor to the MP of the 8th Parliament, the lawyer, the partner of our firm, Ruslan Siderovich. Please, the floor is yours, Ruslan.
Дякую за надане слово.
Thank you for giving me the
На початку
floor.
таку
In the
коротку
beginning, I'd like
рефлексію
to make
скажу щодо
quick comments
попереднього виступу.
on the previous presentation.
На жаль, це є
Unfortunately,
така повальна негативна практика,
this is the
яка
general negative practice,
якою держава дуже часто
which the
намагається
state often is
зруйнувати
trying
принцип
to
правової
use to ruin
визначеності,
the principle of legal certainty, one of the key elements of the rule of law.
І прикладів таких
There
можна
are many
називати
examples of
велику
this.
кількість. І гарна ремарка, що повинна робити держава, в цьому випадку вона не повинна робити нічого.
Do nothing in this case.
І я хочу нагадати нам всім, що коли вводився судовий збір для сплати органами державної влади, такими як прокуратурою і Державною фіскальною службою, службою, вона у нас знаходиться в стані перманентного реформування, було дуже багато, скажімо так, нарікань.
There were many
Але насправді, на мою
criticisms,
точку зору,
I believe that
навпаки, кількість необґрунтованих
the number of
позовів з сторони
ungrounded
держави,
claims from
необґрунтованих
the
апеляційних скарг, вони
the
суттєво
cassation,
зменшуються.
the appeal claims, they are
Переходячи
on the
до
reduction,
теми моєї
Moving to the topic of my presentation,
виступу, нещодавно, буквально в понеділок,
on Monday,
була конференція, яка
there was a conference organized by the Council of Europe
питання,
to discuss
пов'язані з
matters
виконанням рішення
related to
Європейського
execution
суду з
of
прав
judgments of the
людини.
European Court of Human Rights.
Я хочу закцентувати
I would like
свою
to
увагу,
focus my
власне,
attention
на
on
інституційному
the
статусі,
institutional status and institutional capacity of the Parliamentary Subcommittee on Execution of Judgments of the European Court of Human Rights, and to explain why, in my perspective,
це є вкрай важливо.
Is extremely important.
Фактично, та робота,
As a matter
яку
of
я
fact, the work which I carried out
за час своєї
in
парламентської
the time of
діяльності
my
була в
parliamentary
значній мірі
activity
спрямована
was mostly dedicated
не
to
лише на створення,
not
а й
only to
посилення
establishment, but also to
інституційного
strengthening
статусу.
the
Я
institutional status. And I still believe that this is extremely important.
Перед тим, як перейти до можливості, на мою точку зору, застосування принципів екс-анте і екс-пост для надання відповідного функціоналу цього підкомітету, я поясню, на чому ґрунтуються мої думки і чому я вважаю, що вони можуть бути достатньо ефективними і можливими до своєї реалізації. Будучи членом Комітету з питань правової політики і правосуддя Верховної Ради
Being a member of
скликання,
the head of the committee, I'm also going to be the member of the committee on constitutionality.
Одна з задач
One of the tasks
даного комітету і підкомітету полягала в перевірці кожного, підкреслюю, кожного законопроекту, який надходив до українського парламенту на предмет відповідності Конституції України. В даному випадку я хочу звернути увагу, що відповідно до статті 22 Конституції України права і свободи закріплені Конституцією не є вичерпними. Стаття 9 Конституції України нас кореспондує до міжнародних зобов'язань, в даному випадку
In particular, we talk about the
Європейську конвенцію захисту прав людини і відповідно рішення Європейського прав людини для нас в Україні є одним з джерел права. На мою точку зору, надзвичайно важливо, щоб в парламенті існував відповідний підкомітет, який би міг через себе фільтрувати усі законодавчі ініціативи до моменту, коли вони стають законом. Цієї ж позиції притримується і Венеційська комісія. В своєму висновку, який вона ухвалила на 6-му пленарному засіданні 11-12 вересня 2016 року. В пункті 108, 113 в розділі еталонні тести, власне кажучи, згадується принцип екс-анте, який існує і в ряді інших держав, членів Ради Європи. Наприклад, згадується фінський досвід, де парламент наділений повноваженнями попереднього контролю. Тобто, в буквальному перекладі екс-анте це означає before the event. Тобто, функція упередження, вводячи трошки жарт у свій виступ, є такий жарт, що розумний завжди знайде вихід з ситуації, мудрий в неї не потрапить. Застосування даного принципу в парламентській діяльності, воно повинно зробити український парламент мудрим, який убезпечить його від прийняття законів, які порушують ті чи інші принципи, які закладені в Європейській конвенції захисту прав людини. Я приведу практичний приклад застосування даного принципу за час моєї парламентської діяльності. Було внесено свого часу два законопроекти, основний та альтернативний, щодо законодавчого регулювання порядку проведення мирних зібрань. Проведення мирних зібрань є конституційною гарантією, однак Конституція нас відсилає до необхідності прийняття відповідного закону щодо відповідної форми державної влади, на якій покладена гарантія забезпечення даного конституційного принципу, діяти відповідно до статті 19 Конституції в межах порядку визначених. Тому закон, безумовно, що є вкрай важливим і вкрай потрібним. Так ось, при аналізі обидвох законопроєктів, як основного, так і альтернативного, нами було встановлено, що обидві законодавчі ініціативи суперечать практиці Європейського суду з прав людини, численній практиці, де Європейський суд з прав людини постановляв рішення щодо інших країн, членів Ради Європи.
which are also
На моє глибоке переконання, власне, такий підхід, він здатний забезпечити неприйняття законів, які можуть створити проблеми, яких на сьогоднішній день ще немає, або вирішити їх у неналежний спосіб. Приведу інший приклад. Приймалося, так і не був прийнятий в остаточній редакції законопроект щодо ліквідації заборони на проведення страйків. Це є справа Веніамін Тимошенко проти України. І в цьому законопроекті з одного боку вводилася недопустимість заборони проведення страйків з одного боку. З іншого боку, появлялася норма в даному законопроекті, яка створювала для відповідних органів державної влади надмірні дискреційні повноваження, які могли би все ж таки убезпечувати заборону на проведення таких страйків. Відповідно, поява такої норми в законодавчому полі України загрожувала створенню іншої проблеми, яка йшла розріз з двома принципами такими як правова визначеність, таким як заборона на встановлення свавільних дискреційних повноважень відповідних органів державної влади. Таким чином, негативний висновок підкомітету з питань виконання рішень Європейського суду з прав людини, на моє глибоке переконання, мав би слугувати таким своєрідним блоком для прийняття ухвалення відповідного законопроекту, так як таким блоком існує висновок підкомітету з питань конституційності, який може виявити суперечність нормам Конституції того чи іншого законопроекту. Разом з тим, так само є вкрай важливим принцип експост. Це вже стосується безпосередньо виконання вже винесених рішень Європейського суду з прав людини. І це стосується, безумовно, що як заходів загального характеру, так і заходів індивідуальних. Безумовно, що особливою зоною уваги парламентського підкомітету парламенту в цілому мали би бути заходи загального характеру, які має виконувати Україна. Роль підкомітету, на мою точку зору, мала би виглядати як передусім комунікаційний майданчик між усіма членами парламенту, тому що заходи загального характеру можуть стосуватися і стосуються дуже різних сфер. Це є питання пов'язані з кримінальною юстицією, це питання пов'язані з свободою слова, це, як я вже згадував, питання страйків на транспорті, це часто обговорювані заходи загального характеру, що випливають з рішення Іванов проти України, та Бурмич проти України, та й багато інших. На цьому комунікаційному майданчику на базі підкомітету мала би розроблятися дорожня карта по виконанню заходів загального характеру, яка би забезпечувалася не лише прийняттям відповідних змін до закону, а їхнім виконанням виконавчою владою та належним застосуванням відповідних законодавчих ініціатив. Таким чином, ми би отримали спільну розробку усіх трьох гілок влади по реалізації таких завдань. Це відповідало би так само принципу повного циклу публічної політики. Адже тоді і полісі адженда, і зелені книги, і білі книги, і вся дорожня карта виконання таких заходів загального характеру була би зрозуміла як всім акторам, безпосередньо усім громадянам України і, безумовно, нашим західним партнерам. І тоді комунікувати відповідні рішення представнику українського уряду на засіданні комітету Ради Європи, очевидно, що було б значно простіше значно комфортніше.
And much more comfortable.
Окрім того, функцію підкомітету з питань виконання рішень Європейського суду з прав людини в частині забезпечення парламентського контролю, що стосується заходів індивідуального характеру, ми б змогли отримати обов'язкові звіти відповідно уповноваженого уряду по виконанню рішень Європейського суду з прав людини, з тим, щоб, по-перше, забезпечувати належну комунікацію між урядом і парламентом, який є репрезентантом українських виборців. І на основі аналізу отриманих даних від повноваженого українського уряду краще планувати свою законодавчу діяльність. Для прикладу, я скажу, що можна це, звичайно, частково пояснити великою зайнятістю, але в Україні на сьогоднішній день ані в уряді, ані в парламенті немає систематизованого переліку заходів, усіх заходів загального характеру,
general measures that Ukraine has to perform to execute the decision of ECHR with the priorities indicated and also the time plan for that. I will take as an example these two painful directions. The first one would be violation of Article 3 of the Convention, which pertains to languages in which
осіб, які відбувають покарання. Очевидно, що дане питання є надзвичайно складним, і його вирішення лежить не лише у законодавчій площині, не лише в площині тих чи інших дій органів бенефіціарної служби і органів юстиції, воно стосується так само питань фінансування, оскільки вирішення даного блоку проблеми, воно потребує доволі таких значних бюджетних асигнувань. Так само стосується дуже великих значних бюджетних асигнувань вирішення проблем, пов'язаних з справами Іванова і Бурмич. Разом з тим, визначення пріоритетності розв'язання даних проблем з аналізом в частині часово-просторового континіуму нас на сьогоднішній день немає. І тому відверто дуже складно в Україні комунікувати, яким чином ми бачимо вирішення даних питань на засіданнях Ради Європи. Я бачу тут деякі запитання.
I see some questions here asked here. Maybe I should try to answer those. Ruslan, if you are already finishing with your main report, I'm going to quote those questions. You can actually answer them. Or you can
основні, я підбиваючи вже висновок свого виступу, таким чином застосування принципу ex-ante before the event і ex-post after the fact, ми зможемо отримати якісний структурний підхід до виконання рішень Європейського суду з прав людини, який розуміти не лише в буквальному вчиненні конкретних дій, що стосуються заходів індивідуального характеру або отримання справедливої сатисфакції, а ми зможемо отримати системну роботу від законодавчого органу, який зможе скомунікувати всі органи державної влади і отримати прозору і зрозумілу роботу наперед як для українських громадян, так і для наших західних партнерів, і в принципі всіх акторів, які можуть стосуватися та чи інша проблематика, чи ті чи інші гарантії Європейської конвенції захисту прав людини.
Thank you, Ruslan. Well, the question was about, which is about using actually the, and you're changing the legislation for within this general measures. That this first question. The second question, which should be the mechanism of parliamentary control with the lack of initiatives and general measures
coming from the government or not coming from the government?
Я почну з питання парламентського контролю. Одна з моїх улюблених тем. Звичайно, що я з сумом спостерігаю за тим, що у нас так і немає закону про тимчасові слідчі комісії. Тому що в принципі, питання парламентського контролю – це є взагалі ключова задача будь-якого парламенту. Навіть якщо просто подивитися на історію парламентаризму, як зароджувалося сучасний парламент, це є передусім контроль. Тому контрольна функція парламенту, вона є ключовою, навіть якщо подивитися в суть законодавчої функції парламенту, вона в якійсь мірі, можна сказати, є похідною від контрольної функції, тому що закони все рівно виконує уряд, і через в ряді країн члени парламенту навіть не мають права законодавчої ініціативи, тому питання прийняття закону про тимчасові слідчі комісії є вкрай важливим. Проте, якщо ми говоримо про парламентський контроль саме в розрізі проблематики рішень ЄСПЛ, то навіть існуючої законодавчої бази є достатньо, потрібно лише законодавча воля, вірніше, політична воля парламенту і політична воля уряду. Як правильно мала би бути ця організована робота? Відповідні міністри, відповідні профільні заступники міністрів мали би регулярно приходити і звітувати про свою роботу перед профільними парламентськими комітетами. Коли ми говоримо про мою ініціативу щодо обов'язкового звітування відповідного повноваженого уряду у виконанні рішень Європейського суду з прав людини, такої законодавчої норми справді немає. Але з іншого боку, найкраще працюють ті речі, які формуються, виходячи з традицій. Я приведу приклад. У нас є обов'язковий звіт перед парламентом Уповноваженого Верховної Ради з прав людини. Разом з тим, на превеликий жаль, що за моєї каденції 8-го скликання ми не бачили жодного звіту попереднього Уповноваженого з прав людини. Так само я, відверто кажучи, можливо, я щось пропустив, але я не бачив звіт Уповноваженого з прав людини сьогодні діючого пані Дениса. Я зараз не критикую її діяльність, але я просто привожу приклад, що коли норма є, але немає політичної волі по її виконанню, вона може просто банально не працювати. Тому для того, щоб налагодити цю комунікацію, налагодити це регулярне звітування, потрібна передусім політична воля. І не лише голови профільного підкомітету, тому що цього буде достатньо мало, а це повинна бути воля і в самому комітеті, і керівництва парламенту, які повинні просто домовитися, що, скажімо, там, бодай раз у квартал будуть обов'язково проводитися комітетські слухання, на які буде приходити відповідно повноважена особа, будуть запрошуватися відповідні профільні громадські організації, які будуть аналізувати, що відбулося за останній квартал в галузі виконання рішень Європейського суду з прав людини, які появилися нові проблеми, куди поділися старі проблеми, яким чином у нас відбувається вся ця динаміка. А перше питання, можна повторити, поганий зв'язок, я щось трошки злив.
Well, the first question was about whether there were parliamentary hearings about the state implementation.
На превеликий жаль, парламентські слухання не проводилися, і це один з ключових моментів для підняття на серйозний рівень порядку денного політичної дискусії по цьому питанню. Мною було зініційовано проведено доволі такий масштабний захід у вигляді
the form of committee hearing, and it was, if I'm not mistaken, I think it was in March 2017, after which I tried to organize parliamentary hearings as well. The representation at the committee hearing was rather decent. There was Павло Пушкар, Елена Ян, Marie Claire, so I mean, you understand that the Council of Europe had lots of representatives, practically all line NGOs were present, the Minister of Justice of there. So, I mean, so they were there. And after the conference in Strasbourg, and
сьогоднішні члени українського парламенту, присутній Андрій Коса, тоді він був головою підкомітету, зараз він є комітету Верховної Ради. Нами було досягнуто розуміння важливості проведення парламентських слухань. Такі були призначені на березень 2020 року, але у зв'язку з епідеміологічною ситуацією вони не відбулися. Я надіюся, що як тільки епідеміологічна ситуація зникне, парламентські слухання все ж таки відбудуться. Чому я вважаю, вони є дуже важливими? Тому що якщо ми говоримо про підняття інституційного статусу парламентського підкомітету, ми повинні досягнути розуміння на найвищих політичних рівнях. І я би хотів бачити присутніми на таких парламентських слуханнях високих парламентських представників. Я надіюся, хочу надіятися, що долучиться Дмитро Кулеба, який свого часу був України у Раді Європи.
He used to be the ambassador of Ukraine in the Council of Europe. He is well aware of the problems related to the decisions to the judgments of the European Court of Human Rights. I can see that in the governments, these matters are taken care of by the Vice Prime Minister Alexei Reznikov. He started to work on this. He is a well-known professional lawyer. No doubt that without the Minister of Justice, we cannot deal with these matters, and if we manage to raise the level of this political discussion to a sufficient level, all the following decisions at the level of parliament and the government will be easier to implement. Why do we need to raise the level of political discussion on the matters of execution of the judgments of ECHR? If we talk about the governments, the MOJ efforts are not sufficient. Very often to solve the measures of general character, general nature, we need to combine several agencies. We need to involve the Ministry of Finance because funds are necessary to resolve this. Often this is related to the state treasury, to the pension funds of Ukraine, to the Ministry of Social Policy, and a number of other areas and sectors. So this level of political discussion should be controlled by the senior officials in the government and in the Ukrainian parliament. Thank you very much, Mr. Ruslan. Thank you very much indeed for your presentation and your vision. Now I have to remind you that Ms. Valeria Lutkovska is not desired to be listened to the parliament, and she had to report by the public radio and public TV in the past. Now the presentations by Ms. Denisova, she didn't make any presentation to the parliament, I believe. So before we move to the next presentation by Mr. Nazary Stetsik, I would ask Mr. Kuczynski to answer questions raised by Mr. Pablo in the chat. It is about whether this is the systemic problem and the regulation of property and property relations in Article 1 of the Protocol 1 is to this related to the Zelenchuk case. And this is the question to you, Nazar. Please be brief.
Ну, звичайно, я вважаю, що у нас системною проблемою є взагалом захист прав власності, яка коли-небудь належала державі, тому що це в нас стосується будь-що. Це питання реприватизації, виділення земельних ділянок і так далі, і так далі. Єдине, що, як на мене, сильно відрізняє випадок це з батьківською турботою, це те, що дуже чітко прослідковується, як держава веде полювання на майно, яке належало профспілкам, тобто від законодавчих актів і так далі, цілеспрямовано йде удар по одній групі. Але я, наприклад, з жахом прочитав недавно інтерв'ю голови фонду Держкомзему, тобто, який завідує всіма земельними ресурсами, який з радістю повідомив, що у нас ці 30 років неправильно велися реєстри, хто насправді є власником земельних ділянок, абсолютно незрозуміло, і тому вони все це починають збирати і передавати для роботи прокуратури. Тобто, фактично, була закладена бомба, якщо це відповідає дійсності, а не черговий піар, то фактично будь-які власники будь-яких земельних ділянок вже ні в чому станом на сьогодні не можуть бути впевненими. Якщо говорити про знамениті Цюра, то, ну, звичайно, що якщо держава також нічого не робить для вирішення цього питання, і мені здається, що якщо так ще трошки потягнеться, може справді вже буде стояти питання, що це все-таки не контроль вже права власності, а фактично ще є прихованою формою позбавлення права власності, особливо якщо Держкомзем справді захоче переглядати всі земельні відносини.
Thank you very much, Nazar. Now we have the chance to fit our agenda and pass the floor to Mr. Nazar Stetsik, the Associate Professor of the Department of the Theory and Philosophy of Law and Deputy Dean on Scientific Research of the Lviv National University. Please, the floor is yours. We will discuss what are the standards to be used for the national courts of Ukraine, they should be guided by them, and what is the practice and how do they demonstrate the cohesiveness in their views. Please, Nazari. Good afternoon, dear colleagues, dear participants of the forum. First, I'd like to thank the organizers for the chance to speak, to present my results of some of my scientific research and expert activity. If the organizers have the opportunity to give me the access for the presentation, to share my presentation, I'd like to use this opportunity. This opportunity is given to you, Nazari. You can try to share your screen and start your presentation. As I have mentioned, my topic is about consistency and cohesiveness of the practice of the case law of national courts. It is quite interesting and important. It goes in line with the matters that were raised yesterday and today. Mr. Mankubira mentioned the lack of consistency or lack of certainty in the practice of the Supreme Justice Council. Yesterday, Dmitry Anatolovich mentioned the problem of moving away from the procedural opinions or procedural legal positions. These matters are really important in the aspect of the practice of the European Court of Human Rights in terms of forming of the appropriate standards in particular. I have to mention that these matters for a quite long period of time constitute my scientific interest. For several years I work on my doctorate thesis, which is quite similar. At our school we implemented the electoral course, the case law, in which we discuss these matters which are important. Several years ago we set up with the department and our head of the department, Vitaly Kosovich. We had interesting projects within the OSCE program, New Justice, analysis of the case law of the new Supreme Court. If there is time, I'll mention about this. So, to show the significance of this topic, at the end of November this year, the Supreme Court organized jointly with COE an interesting conference which was dedicated to these matters. not to recreate generally known things, I would like to draw your attention to 3 key problems. In my generalizations and observations, I try to be brief and laconic. First point I'd like to mention is that the European standards of consistency and cohesion of the case law are already formed and developed, and the ECTHR and the Council of Europe remains the freedom of discretion to the countries, to the member states, on how they should organize their judiciary system to be in line with these requirements of consistency and cohesiveness and stability of case law, but still they form some minimal requirements and standards in this part, which I'll discuss. And the second point, the principle is not new for our legal system. Since 1990s and the early 2000s, at the level of the legislation, some mechanisms was set forth, this requirement was set forth at the level of different conferences. I had the chance to participate in some of them, and it was discussed, these matters were discussed, and these standards are not new for us. There is objective needs of the legal system and judiciary practice and to have this consistency and unity and cohesion. But I have to state that we're still at the level of this doctrinal value, recognition and normative enshrining of this, which is not bad, but we're slow and chaotic, we're sporadic when we form this comprehensive mechanism of consistency of case law, and also the monitoring of efficiency is important for ensuring this practice. And I'd like to continue that the European Court of Human Rights pays attention to this. The mechanism may be in legislation, it may be envisaged, but to evaluate its efficiency, its performance is what is important. We have to draw the attention to this generalization that in the practice in the case law of the Supreme Court, of the Great Chamber and Cassation Courts, there are positive trends on ensuring the unity of the case law, but there are some critical comments which I'd like to mention today. First, we need to start with doctrinal importance, terminological aspects. The legislator uses 2 terms, sustainability and uniformity, although in legal sources and literature, and even in the legislation which lost its effectiveness, there are other synonyms or terms like single meaning, single type, unification, and others, and this shows the richness of Ukrainian language, but it creates researchers some difficulties related to having to define, because there is a term which has some phenomenon, it signifies some phenomenon, or are these just synonyms? In English, there are less terms which are used, but there are problems of translation of these terms into Ukrainian. And traditionally, we use the opposite antonym meeting in the different practice, violation of unity, non-homogeneity, heterogeneity. I'll not speculate on these relations and these terms. I'm sure that you may feel this or understand this. The sustainability and uniformity are characteristics of the case law which reflect 2 components. The sustainability is temporal and timely aspect, which shows the stability of practice, while uniformity of legal practice shows the contents, the quality aspect of the evaluation of the set of court judgments. If there is practice, if there is case law which is stable, but we observe diversity, non-uniformity, this is long-term diversity which may constitute the problem for the legal system. Instead, the ideal situation when the practice is both stable and uniform, But this is ideal in practice, in real life. This ideal consistency and stability is impossible. It cannot be absolute because social relations develop. There may be errors in judiciary practice which require corrections. It is obvious that there has to be a harmonic link between the sustainability, unity of practice, and its development. Obviously, the main task is to be looking for this compromise or balance or harmony between these categories. We have to rely this, in this we have to rely on the Supreme Court. And due to this, I'd like to remind you the interesting work by the former judge of the European Court for Human Rights. For 18 years, he was at the court. Boston Maria Shabancic. He published the interesting book on the past view on the activity of the European Court of Human Rights. He briefly, concisely, and very good, positively formulated this well-known doctrine. Stare decisis in English. Stare decisis. The similar cases should be solved similarly, in the similar manner. Let's move to the characteristics of European standards. I'll not read them out. The only thing I'd like to say is they were formed gradually. They started to be formed in the 1990s, in the years 2000, in the series of decisions of the European Court of Human Rights. It started to develop its approach. Some aspects of the doctrine were reviewed at that time. And here I have to remember the case Nejit Shachin and Pergan Shachin, which is well known in the expert community, in which the CTHR formulated this criteria of uniformity and consistency of the case law. And I have to remember Surkov versus Ukraine case, in which the court, based on contradictory decisions of the Supreme Court on reimbursement of VAT refunds, it declared the violation of Article 1 of Protocol 1 in terms of quality of the legislation. I have to mention that the European Court of Human Rights, this requirements of consistency of case law can be reviewed separately in the context of Article 6 in terms of fair court review, or in the aspect of other articles of the Convention in terms of quality of legislation. It's obvious if the practice is not consistent and contradictory, it shows, especially in the Supreme Court, it shows that there is problem with quality of the law. Also, the presentation of the Supreme Court has mentioned there are problems of legal certainty and consistency of legal practice. And the climax of forming of the standard is well-known opinion of 2020 and 2017, when a consultative Council of European Judges, based on journalism, the report of some members of Council of Europe, they summarized this in this part. I will not quote the standards. They can be grouped into doctrinal, value, ideological part, which justifies the significance and importance of the requirement to ensure unanimity of practice. They mention the legal certainty, the rule of law, the trust in judiciary, and other important points. But I'd like to focus more on instrumental or practical applied components. And here, the European Court of Human Rights pays attention to this, that besides the enshrining at legal level of this mechanism has to be implemented, it has to be evaluated, its efficiency has to be evaluated. And also, what is very important is the matter which is addressed by the Consultative Council of European Judges. It's the value and importance of case law instruments in forming the uniform judiciary practice. And here, in this opinion, if you have the chance to read it, there is the chapter when the Consultative Council of European Judges analyzes the case law of the continental legal systems and English law. However, they mention that overall, for the countries members of the Council of Europe, there is increase of significance of the case law instruments and especially decisions of the Supreme Court in the specific cases. Due to this, I'd like to mention the unique judgments which was made back in 2006 by the Constitutional Court of Lithuania, where they formalized this doctrine of precedence in their decision. They clearly said that if lower instance courts do not follow the link tied by the position of the Supreme Court, then this may contradict the principle of legal certainty, and this may contradict the right for fair trial. And regarding our experience since 2015, after adoption in 2016, the law on judiciary and status of judges, it was formalized that opinions with application of the provisions of the law exposed by the Supreme Court are compulsory for all public agencies, and other courts should take them into account when they apply these provisions of the law. I have to say that this was not for the first time when this precedent nature was enshrined back in 2010 and 2011. At the legal level, we had some formulations that the decisions of the Supreme Court of Ukraine are compulsory. But with the view of lack of time, I will not discuss this in detail. And another important aspect of the instrumental components identified by the Consultative Council of European Judges is the mechanism of access to the Supreme Courts, in terms of the fact that Supreme Courts have to decide on the matters which are important to ensure the activity of the case law. We have to remember this wording which we have in our legislation. It recreates similar formulations about the rare legal problem or principal matter which has significance for case law, which has to be this cornerstone, which has to be the groundworks of forming and ensuring consistency of the case law. In our procedural law, we have recorded this ground of transferring the case to the Supreme Court, Great Chamber. This exclusive legal problem is necessary to ensure development and application of the uniform court practice.
Well, the Great Chamber and the Cassation Courts already tried to formalize these conditions and also solving this legal problem through quality and quantity criteria. The quality that shouldn't be just in one case, it has to be significant for other cases as well, and the quality that actually we observe certain defects of legislation, that this problem actually has significance. So in this decisions, we can actually talk about it in more detail, but I would like to draw your attention to efficient implementation of this authority by the Grand Chamber. And actually, until 31st of October 2018, you are going to see that out of these decrees, only 20 were adopted by the Great Chamber about this exclusive legal field, where they solved this issue. And actually, they brought it back to the Cassation Courts, and it wasn't a legal problem like that. So by this project, we actually commented to this chamber to somehow pay more attention to solving these legal problems, also recognizing that the court was really overloaded by a great number of these places and actually about this disputes. But I managed to analyze the practice for 2 last years, and there is also a tendency, and actually how to work with this clear legal problem. Well, as for the Cassation Courts not wishing to actually solve this cases, they pass it to the Great Chamber, and then it brings it back to the Cassation Court. So we observe this on non-academic same. Sorry, there's ping pong, in the structural departments of the court. Well, it is obvious that the Great Chamber of the court has to solve these problems because this is actually the cornerstone for forming a single judicial practice. And also, we analyzed the decrees on that, and actually it looks like the percentage of digression is much higher than the formation of this legal position. So this might also testify to a trend that actually the practice of Great Chamber itself is not stable and often it doesn't change often, so it might be a threat for the legal definition stability. And also another instrument that they pay attention to is actually the inadmissibility of using explanations based on generalization of special practice, the so-called plenum decrees. And also I have to immediately say that in 2010 and also in 2015, the plenum first was devoid of this authority, but in 2017, actually, they can now adopt this based on generalization of that. And actually, this could be a threat in which part that actually there could be conflicts on the one hand between the plenum and also the decisions which are going to be adopted further on by the Supreme Court. For now, this plenum has not adopted a single decree like that, but the potential use of this authority can be a problem further on for interaction with other decisions of the Supreme Court. Also, another instrument would be the accessibility of case law that the Consultative Council actually pays attention to. It is about publishing such decisions and also the restructuring, the fact that we should actually find these legal positions. And here that we can positively describe the activities of the Supreme Court because it adopts the digest, the reviews of the court practice, the case law, and at this conference, which was taking place associated with ensuring that, and Valentina Dryshevskaya, actually a respected head of the Supreme Court, said that actually there was a very interesting practice ongoing, the web portal for case law. It should work in the second half of 2021. And I think that this is going to be a useful instrument to ensure this unity and stability of this practice. Because the legal community and the lawyers, they will be able to more conveniently use this system. Unfortunately, due to the lack of time, I cannot stop on an important issue about temporal aspect of this case law decisions. They emerge in the practice of the Supreme Court. In particular, this pertains to the issues of how to work with this cases we had at the moment of case review, and also then they could have actually come digress from the legal position. Should they have this reverse action only prospective? Should there be an urgent action? That's also an aspect which can spur problems in the court practice. And finally, I would like to pay attention to the fact that as a recommendation also for a legal community that we need to monitor the practice of Supreme Court in the part of efficiency of functioning of this system. Well, and now I thank you for your attention, and it is with great pleasure I'm going to answer a question if you have any. Thank you, Nazari, for a very interesting presentation. It was very useful research, in my opinion. There are questions for you. Whether our procedural legislation orients at ensuring the unity of case law with regard to the review of court decisions in cassation. Well, in that part, yes, there are some procedural mechanisms, but I would like to talk about the feasibility and the efficiency of such mechanisms, like the grounds for appeal, as well as the presence of a legal problem, because actually it's only if it's an exclusive problem like that, and our participants. So actually in cassation, and we managed to actually work it all out, but there are some mechanism procedures like that. Actually, there are also this mechanism like that in Lithuania, and actually it would expand these procedures. But here I would also like to draw attention to the fact that, I mean, this mechanism also requires some stability, and if we actually make changes, it might be debalanced again. And actually, so that the Supreme Court in its court decisions could also form some doctrines and criteria of access to the court, and actually these issues, they are also important and they require that. Well, thank you, Nazari. Svetlana Chyliuk is not going to speak today. She has some circumstances. She passed her greetings, but finally, we are now going to be in time with our final report of the second day of the forum. And I invite to the floor Mikhailo Savchenko, who is the professor of Uzhgorod National University. And actually, this is going to pertain to whether it is efficient to protect human rights. In national courts, international courts, there is certain, is the adversariality or competition there? So, Mikhailo, the floor is yours. Good afternoon, dear participants of the forum. Now I'm going to switch on my presentation. It's all working, don't worry. So let us look at the competition of national international courts, and actually our constitutional court worked on that. They have good decisions, they have rather doubtful decisions on that, and if it is about the application of international law and the constitutional justice or Supreme Courts, we are going to talk, those in the international courts, we are going to talk about convergence of court jurisdictions, so the mutual influence of the content of these decisions, and therefore the transfer of some legal constructs to the national soil. The main criterion here is the principle of right, but if we talk about that, we have to say that these principles are interpreted by specific legal circumstances of the case. So that is why, in general, if we generally talk about the rights, which we cannot actually say that we should work on that. There are different competitive approaches about this or those legal principles. You can see on the slide is the Supreme Courts, the national institutions, and actually also constitutional courts, and also the international court and all that. So, of course, this transfer to the national ground, this is actually, this is about ensuring better protection, and actually the constitutional court is actually can review these positions and to actually improve the protection. How it is done by our constitutional court? So one of the decisions was actually the is about where the Constitutional Court formed the principles of friendly treatment. So it is about putting the person into psychiatric and also the court of freedom, and they use the practice. And the thing is that there are just additional reservations that they guarantee this. And actually in this part in the Article 29, we also talk about criminal procedure there. So if we take the first part of Article 29, it is not exhausted by criminal procedure guarantee of human rights. They talk about guarantees of protecting the freedoms. And for this reason, Article 5 of the Convention says about different grounds for limiting the freedom. For example, when the person is homeless, and if, for example, the mental state doesn't allow the person to do it, but it is all done within court control. So the following decision of the Constitutional Court is the first in the new year. It was the case where there is this principle is mirrored, that there are cases, especially if it is the constitutional part, that actually the national constitution can have higher standards of protection, and actually that is why they do not actually take that into account. There is going to be there, and there is another jurisdiction, and also that. Well, in this case, we were saying that actually these constitutional guarantees, they do not allow to actually have that in the constitutional. I mean, it is here just presented that this is associated with the violation of constitutional guarantees, and even though really we are talking about an obligation to declare your revenues, in particular by officials, including the judges, and of course there was criminal liability for that, so that when there was significant discrepancy, the person that declares the revenues with the actual active data, and the court noted that the presumption of innocence process is violated because they evoke the word evidence, that this actually the person has to prove something, even though actually it is only indicated in the declaration, and that is it. So actually, until today, this situation is not solved yet, and it looks like, I mean, if I was, it could be that, but actually, this actual decision was discredited, and we could actually concentrate on other issues. If we compare those various approaches, we are going to see that in practice there were these approaches that they actually they were applied in the way so that it was efficient enough. And I mean, the convention guarantees not just illusionary rights, but the rights that actually have actual impact. And I mean, the convention has to be interpreted according to those various parts, according to which they are there. And I mean, again, here, this is the decision of the Court of Human Rights, and So I guess that the main is actually they interpret in a way that they actually caused the limits of the human rights that in the end, I mean, that had to be guaranteed. And therefore, that puts certain obligations on the court about interpreting these provisions. So the Palace of Justice, EU, the Luxembourg Court says that the law order of the EU is a special law order, which is rule of law over the national law of the member countries. This is somewhat different, the jurisdiction of the European Court of Human Rights. The court respects ECHR practice in the field of human rights. And I would like to draw your attention to this approach of the court, because in this respect, it confirms the general approach about the understanding of human rights in two meanings, like the rules and the principles of law. If you take the analysis of legal practices and this human rights and legal texts actually they perform the main role about the interpretation of these principles. And the EU court also said that these are going to be the factors in improving the legal decisions. And of course, this also says that the applying of this law is about constitutional traditions as well.
This became the source of interpretation from the ECJ in conclusion 213 in December 2013. On the following. Can the EU join the European Convention on Human Rights and recognize the jurisdiction of the European Court of Human Rights? The court mentions that EU is a supranational institution. The European Court of Justice is also a supranational institution, but the member states of the EU are participants of the convention, and this is sufficient for the conventional mechanism of protection to be effective. So the court gave negative opinion on EU joining the European Convention. This is the specificity. Once again, I'd like to emphasize that despite everything, the ECJ said that they respect principles of law formulated by ECTHR in the area of human rights. Now the decision of Federal Constitutional Court of Germany on the case of the procurement of the public sector of 5th of May this year, which envisages the accumulation of resources in fighting against coronavirus infection. And the German court notes that European Central Bank violated the principle of subsidiarity and proportionality and went beyond these basic principles, and the German court took the position of protection of national interests, and they stated that European Central Bank went beyond its mandate, although in fact, despite the reference to the principle of ultra vires, which is rarely applied in international legal disputes, as It doesn't always have significance for solving the case. Here, what is meant is the regular practice of signing disagreements and making appropriate decisions. In fact, we talk about political consultations here and approval of financial capabilities of these programs, reforms at national level and supranational level, and redistribution of resources to overcome the consequences of the epidemic. At the slide, you can see the exchange of positions between the Federal Constitutional Court of Germany and the response of the Palace of Justice as of 8th of May 2020. The courts noted in order to ensure equal application of EU legislation, the jurisdiction of OSCE that was created for this purpose by the member state to rule that the acts of EU contradicts the EU legislation. Only OSCE can decide on this matters and not Federal Constitutional Court of Germany. This follows from general understanding of interpretation of the principle of ultra-virus that it has substantial impacts. Usually it is not taken into account. I'd like to give the example of the decision on the debt of Yanukovych of $3 billion, which Azarov's government borrowed in December 2013, and which is the subject of the dispute. And the Appellate Court of England and Wales mentions that there are two types of powers: actual and ostensible. Actual powers envisage the real relations of the agency, while ostensible powers describe the situation when one individual refrains from the powers of another person, which the agent performs on behalf of the settler, and it may appear in the circumstances when the trustee believes that agent can perform some operations on behalf of the principal. The empowered persons took part in approving these decisions, and it's not clear for me. My German court got involved and started to interpret this situation from the perspective of principle of proportionality and subsidiarity, because it's about political consultations and solving professional economic matters which are carried out at the financial level. And at the end, these are the main provisions I wanted to discuss. Please ask your questions, if any. Thank you very much, Mikhailo, colleagues. Mikhailo, do you feel all right? Are you able to answer questions? I apologize. It's painful to look at this. Maybe you can answer questions by typing. You can save your voice. Colleagues, if there are any questions, I hope that Mikhailo can type the answers to them. If there are no questions, let me know. If there are no questions, we'll finalize this event. I believe that the right of health, is the basic right. In this case, we need to understand that the person needs some rest. I apologize for taking over the powers and making this decision, but Mikhailo has a strong cough. Colleagues, friends, if there are only wishes of health to Mikhailo and there are no further questions. I don't see any, maybe they will be formulated. The presentation was very interesting, Mikhailo. Would you share the link to your presentation, if possible? Everybody will be glad to reflect on this, to think about your points. But for now, using this opportunity and my right as the moderator, I'd like to thank all of you for your attention. The 9th International Forum on the case law of the European Courts of Human Rights was extremely diverse and informative. Thank you very much for your participation, for your activeness. I'd like to thank the listeners and the speakers and the organizers. I hope that in 2021 we will meet in person, we'll be healthy and happy, we'll be convinced in ourselves, in our country, so have confidence in our politicians. Thank you for spending these 2 days together. I wish you health and see you next time in the area of human rights protection and human freedoms protection. Thank you very much. Thank you, Mihaila. Thank you and goodbye.